Good morning, Mr. Pretorius. Good morning, everybody.
Morning, Chair.
Yes, Mr. Pretorius.
Chair, before you is the application brought on behalf of Mr. Tom Moyane for cross-examination of Minister Gordhan. In Chambers, we discussed the various issues relating to condonation. It is not necessary for you to be burdened with any such application for the purposes at least of these proceedings. You did on the 21st of November last year grant an application for condonation in regard to the late filing of 3 applications. That's been dealt with. So with your leave, we may proceed with the application.
Okay, thank you. That will be Mr. Moyane's application now?
Yes.
Yes.
Good morning, Chairperson.
Good morning, Mr. Mpofu. I guess you thought Mr. Pretorius would take a little longer than he did.
Yes, he caught me off guard.
Okay, I'm ready to hear your argument in relation to Mr. Moyane's application for leave to cross-examine Minister Gordhan.
Thank you very much, Deputy Chief Justice. If I may just mention for housekeeping that I appear with my learned friends, Ms. Sebuku and Ms. Daniel from the Johannesburg Bar.
Thank you.
Thank you very much, DCJ. Chair will try to save as much time as possible.
Yes, for what?
That submissions.
Yes, I'm sorry.
Sorry.
Just as I said in Chambers, I have read the written submissions submitted by both parties. I read, obviously, as can be expected, the affidavits in both Mr. Moyane's founding application affidavit, Mr. Gordhan's answering, as well as Mr. Moyane's replying affidavit. So I'm quite familiar with what is there. I've also read the comprehensive written submissions delivered by both parties. Mr. Mpofu, would you like a few minutes to get your
Yes, I think I would, Chair. Yes. One of the things I want to get is the stopwatch so that I can time myself.
Yes, do you need us to adjourn or I must just give you?
No,
okay.
Just 1 second.
All right.
I'm indebted to DCJ. Thank you very much.
Thank you. So I've read both comprehensive written submissions delivered by both parties. So it's not really necessary to repeat everything said there. The idea is that this opportunity should be used to clarify whatever submissions or points that Council might feel need to be clarified or to be emphasized.
Thank you, Chairperson.
Thank you.
Thank you. Chair, in that spirit of saving time, I'd like to start by just putting certain things out of the way.
Yes.
Firstly, that it is not our case, and it cannot be in light of the regulations and the rules, that there is an automatic right to cross-examination.
Yes.
That the regulations are very clear on that. And,
yes.
And I use the word automatic advisedly.
Yes.
Because that's how I read that regulation.
Yes.
Obviously, once granted, there's a right to cross-examination.
Yes.
But
yes.
It's not automatic as it would be in a court of law.
Yes, yes.
The second aspect, Chair, which we again concede up front, is that these are not court proceedings. And,
yes.
therefore, even when
yes.
cross-examination is allowed,
yes.
it's not going to follow
yes.
the exact tracks. So I
yes.
just just so that I'm not accused of that.
No, I think that's important that you started with that, because certain portions of the written submissions and the founding affidavit, maybe the replying affidavit as well, from Mr. Moyane, may give the impression.
Yes.
Yeah, so
That's why I wanted
yeah.
to clear that, yeah.
Yes.
In other words, when we talk about the right to cross-examination, we're talking about it on the assumption that...
If it once it's granted,
once
yeah.
it's granted, that's
Okay,
correct, Chair.
okay.
Thirdly, which gets closer to the meat, because this is raised in the heads of the other side, is that we accept again that at best for us, these proceedings are what one calls quasi-adversarial in this context, but largely they are inquisitorial. So we have no qualms with that either, so we also don't want to waste time on that. Where we start, Chair, is the definition of what cross-examination seeks to achieve in order to support our application to be granted to do so. And we start with the quotation that we put in our heads that from WIGMO, who's the leading international authority on this, who said that cross-examination is beyond doubt the greatest legal engine ever invented for the discovery of the truth. And we have attached a fuller version of that, which we will hand up, where they give examples of why that is so over the centuries, that this is the greatest engine.
Yes.
And the emphasis really we want to put on that quotation is on the truth. How do you find the truth in these kinds of proceedings, whether you call them quasi-adversarial or whatever? And one of the key safeguards is that for evidence to be accepted, it must have been tested somehow. And as I say, one of the best known ways to do so is cross-examination. Now, the issue, if we were in a normal court setting, then obviously the two standards are relevance and credibility. So you may cross-examine in terms of relevance and also as to credibility. Relevance in this context, obviously, will relate to the terms of reference of this commission, will relate to the subject matter and so on the one hand. On the other hand, it will relate more specifically to the evidence of the particular witness, subject to the caveat, again, which is now accepted, that obviously a cross-examiner has more leeway than the examiner-in-chief to cover issues which were not covered in the evidence. But obviously, you can't go on for 2 days asking the witness about where he was born and so on, if that has nothing to do.
Maybe not even half a day, Mr. Bo.
Maybe not even half an hour. That's correct, Chairperson. So the point is simply that there are limits to all these things. It's not as if you just have a carte blanche. And that takes us, Chair, around these general issues to a very important issue, namely the reason, as we've put it in our submissions, the reason why the President appointed a judge, and not just a judge, the most senior judge that could have been appointed, because the Chief Justice couldn't appoint himself, in this.
Well, I was about to say, don't say the most senior.
That could be career limiting. No.
Yes.
But subject to that, the point is that that's one of the safeguards, because the President could have appointed anybody, an accountant or whatever. But the reason why there's a judge is so that those safeguards are almost guaranteed in a way, because the judge will know when to curtail cross-examination. So the big point is that the safeguard against, let's say, cross-examination that strays across the rules is not to have a wholesale ban on cross-examination, which is what is being asked for, but it is simply to rely on the wisdom of the chair that he will, when the time comes, control the proceedings. The second safeguard, Chair, insofar as some issues have been raised, unfortunately, about choice of counsel, is there are 2 points there. One is that Of course, the general legal rules apply. So every citizen has a right to counsel of their choice. That goes without saying. But more importantly, a second set of safeguards is that there are specific rules specified by the General Counsel of the Bar, which would make sure that a counsel is going to cross-examine within certain parameters. And that then becomes a double safeguard because, of course, counsel now and again will stray, but then the chair, so it's a double-barreled safeguard.
Well, you can take it, Mr. Mpofu, that I don't think that you are here to do anything other than perform your duties as counsel.
I'm indebted to the chair. Then I'll move on to something else. Now, Chair, what we really need to look at, I'll just specify a few, well, no, not a few, but some of the issues that make this particular cross-examination important. Firstly, Chair, this is, as we all know, at the risk of stating the obvious, this is the Judicial Commission of Inquiry into allegations underlying of state capture, corruption, fraud in the public sector, including organs of state. It's not, as maybe widely assumed, it's not the Gupta Commission. It's a commission into allegations of state capture, corruption, and fraud in the public sector and organs of state. Much wider. If it was the Gupta Commission, this commission would not have spent 2 weeks listening to Mr. Agrizi, who said nothing about the Guptas. It's because it's a much wider test. The next important thing, Chair, is that there can be no doubt that Mr. Gordhan implicates Mr. Moyane. And the emphasis of the word implicates is very important. That, after all, Chair, is the reason why we were invited here. Remember, Mr. Moyane was not sitting at home watching TV and then saw Mr. Gordhan and said, oh, there he is mentioning me. Let me rush to go and ask for cross-examination. No, we were invited by this commission. And the only reason this commission invited us was simply because we were an implicated party. Now, the word implicate.
Well, let me just say that I think that's a very important part of an important part of the application for leave to cross-examine.
Thank you, Chair.
But before you proceed, let me say this. You will have noticed that if you look at the relevant rule, it enjoins the legal team to give Rule 3.3 notice to an implicated person if a witness's statement implicates or may implicate.
That's correct. That's
Now,
3.3.1.
Oh, okay, I'm not there yet, yeah. My understanding is that the reason why you have may implicate there is based on the acknowledgement that it may be difficult sometimes for the legal team to say whether a particular statement implicates or definitely implicates a particular person, but they may look at it and say, well, somebody might say it does, somebody might say it doesn't.
Yes.
So there is that possibility
Absolutely.
to be on the safe side.
Yes.
Let's give it to them, and if they take the view as it has been taken by some witnesses in certain cases that they are not
Yes.
implicated.
No, Chair,
yeah.
we accept that.
You accept that, yeah.
100%. Yeah.
Okay.
That the rule is broad enough to cover both. My submission with respect, Chair, is that in this case, it is not the second leg. There was actual implication, and insofar that the whoever wrote the letter to us, the commission, I'll use it broadly. The commission actually did cite specific examples.
Yes.
And it used the word inter alia. It said
Yes.
you are implicated in this and that inter alia in the following, and that is because
Yes.
there was, in this case, unlike in other cases maybe, a
Yes.
comprehensive statement which had already implicated us. And I'll go
Yes.
further to say, Chair, that indeed the statement in the box actually went further to implicate us even further than the written statement. So there can be no doubt that we are an implicated party.
I would like to go to that letter because I think it's important,
Yes,
or it
Chair.
may be important.
It may be.
Where do I find it again?
Well, Chair, I was told that the pagination might not correspond. On our pagination, it's 196. Oh, yes, it's, okay, I'll find it now, Chair. It's attached to the answering affidavit. While I'm looking, Chair, let me just say that
Yes, well, we can come back to it.
we
What-
can come
yeah,
back to
we
it. I can
yeah.
paraphrase it
Yeah.
while we're
Yeah.
looking. What
Yeah.
it says is routinely, this is to notify you that you may apply and so on and so on. Within 14 days, you are implicated in the following way.
Yes.
And then it raises two specific issues. One is the tender fraud, let's call it that, in respect of an IT contract. And then the second one is lying to Parliament, which is a second leg. But the point I wanted to make is that even in that notice, and when we find it, it says you are implicated inter alia
Yes.
in this way. So it left
Yes.
it open-ended. And I think that was a wise thing to do, because you don't know what the witness might say, or there might be other I mean, there were 10 files. You might have missed another reference to Mr. Moyane in another place. The simple submission I wish to make, Chair, is that there can be no doubt, and I don't even expect my learned friend, Ms. Leroux, to say that Mr. Moyane is not implicated by
Well, I think in her written submissions, I think she says that.
No,
If I
you
understand
see
them
that
correctly.
it's very tentative. It says in most places and some of the, so I think even
yes.
she couldn't get herself to say.
Okay. Well, maybe let's go to what maybe the
the
crux.
points, yes.
No, I'll let me mention this. My reading of the relevant rules is that is that if you are going to bring an application for leave to cross-examine, obviously you do so because you take the view that you are implicated.
Correct.
Because obviously, even if the legal team of the commission can send you a Rule 33 notice saying you are implicated or may be implicated, if you are free to disagree with them and say,
Absolutely.
I don't know what you're talking
Or
about.
the witness might actually exculpate you.
Exactly. Yeah, so you have got to take a view that you are implicated as far as you are concerned. And then when you make your application, I believe you must say, this witness implicates me when he or she says this.
Yes.
And then you need to then say whether you admit that, but you explain,
Yes.
or you deny that and put up a different version
absolutely.
or whatever. Now, when I was reading Mr. Moyane's founding affidavit, I struggled to find places other than maybe the reference to that IT contract, I think you say it was.
Yes.
Other than that, I struggled to find a place where, or places where he was saying, this is the allegation that is in Mr. Gordhan's statement or in his evidence before the commission. This is what he said about me. And by making this allegation against me, he's implicating me in wrongdoing. And this is my version. it's not true, and here is my version, or it is true, but there is an explanation. This is the explanation. That's what I struggled to find. Yeah.
Yes, Chair. Let me my reading of the rule may be slightly different. My reading of the rule, Chair, obviously the application must set out the basis.
Yes.
But when the rule, the relevant rule, and I'll find it now, it says you must set out the grounds for the cross-examination. I read it as you know, as you set up the ground, let's say in a notice of appeal.
Yeah.
You don't then traverse chapter and verse of the evidence, but you said this is the ground the judge erred in this respect and that respect.
Yeah.
So that's the one, let's call it a narrow reading. A wider reading would say you must then quote every word that the witness said and then say this.
Yes.
What we did say, Chair, very much upfront was that when we put what we call the themes, you remember we put the 5 cross-examination themes.
Yes.
In respect of each, we then put the ground broadly of our disagreement or objection, as the Chair is saying. Except, I think, when we talk about credibility, because there you can't really say, sometimes the credibility question is by omission rather than what the witness actually says. Yeah.
Yes.
But if Chair goes to page 2, I think it's page 2 on every pagination. You'll see that the first one is the easy one. Let's say paragraph 5 of Mr. Moyane's affidavit.
Yes.
As I said, that's the easy one where it says, it was therein pointed out to me that Minister Gordhan implicates me in 2 broad respects, namely 1, my alleged participation in the awarding of a contract or tender to the new Integrated Credit Solutions, a company owned by my alleged friend, Mr. Munyeki. And then the second one, my alleged refusal to account to the minister as a minister in the finance and material issues, the deteriorating relationship between the 2 of us. You'll remember that Mr. Gordhan went on for a long time on that. Alleged ongoing personal institutional attacks by me and Mr. Gordhan in the related relationship issues. One might add there on the ones that I say are easy, the lying.
I'm sorry, what paragraph is that?
5.
Oh, okay,
yes.
Yes.
So 5.1, 5.2, so you might conceptually add a 5.3, which is the lying to Parliament.
Yes.
Those are the easy areas of being implicated.
Yes.
And then we say then, upon a cursory reading of the statement of Mr. Gordhan and other issues raised by him, which directly or indirectly affect me, include, then we list, I won't read them out, we list about 7 other what we call topics.
Yes.
And then at paragraph 7, you'll see that we say the additional issues which are related to the above, but are not directly raised in the papers.
Yes.
And then we list another 7. So it's about 15 issues.
Yes.
And then we say, we group them into 5 for convenience, which is paragraph 8.
Yes.
Then we then say this is the basis of what we say. We say the general credibility and general attitude of Mr. Gordhan characterized by a propensity to distort and spin the facts. So that's a ground on its own. You can't develop it more than that. Then the next ground we say is bias, hostility, and vindictiveness as guiding attitude of the relationship between the 2 of us, leaving no room for professionalism, objectivity, and impartiality in our mutual dealings. And so this calls for any evidence given by Gordhan about me in any ongoing forum, including this one, needs to be taken with more than the proverbial pinch of salt. Then we said the distortion of the evidence in order to support his false narrative of devils and angels, and especially my alleged breach of procurement procedures. Then we say racism on his part and the unbecoming behavior of Minister Gordhan towards me symbolizes regrettable behavior which has no place in the nation we are trying to build, and in which there is no place for looking down upon African people. And then we say the deep role of Minister Gordhan in the rogue unit saga, also referred to as the Sunday Evening Project, which was a form of state capture. Now, the importance of those grounds, as it were, Chair, is that the last one is more explicit. And if your Chair allows me, I'll come back to your question. I just wanted to touch on this question of the rogue unit,
Yes.
on which Mr. Gordhan obviously testified. Our take, Chair, and I need to say this just in case I forget to say it later. Our take is this: given the broad mandate of this commission, if Mr. Gordhan, as Mr. Moyane suggests, and we know that Mr. Gordhan testified that Mr. Moyane went even as to lay a charge about this issue, so obviously he believes this. If Mr. Gordhan was involved in unlawful activity, stroke criminal activity around the rogue unit issue, that, I'm afraid, comes directly to the remit of this commission. Why? Because state capture is just a phrase we've created in South Africa for ourselves. It's a cryptic phrase. But state capture really talks about the creation or the alleged creation of a parallel state, outside of the parameters that we all know. Now, there is no difference between that and setting up unlawfully a rogue unit to spy on citizens, to spy on political opponents, and all that. It's a parallel state that you are creating. It might be on a smaller scale than the grand state capture. So that falls squarely onto the issues. And we know that that is one of the key issues that Mr. Gordhan testified about in relation to Mr. Moyane, not just generally. Because he says, I've been, there's a campaign, a political campaign to discredit me and so on, and it's characterized by, you'll remember there was a whole discussion about the 27 questions. The 27 questions, those 27 questions, the genesis of the 27 questions is obviously the charges that were laid. Now here's the point of cross-examination. According to Mr. Gordhan, Mr. Moyane's actions in laying those charges were motivated by malice and all this conspiracy and so on. According to Mr. Moyane, these were motivated by the Sikakane report, which said that this thing is unlawful, by the Kroon report, which said this thing is unlawful, which Sikakane report, by the way, was commissioned before Mr. Moyane came to work at SARS. And as he says, what reasonable SARS commissioner or CEO would come into a place, find a report that says there has been criminal stroke unlawful activity, and just do nothing? So these are two contesting theories. So it's either, in the end, the chair will have to buy into one of those theories, let me put it that way, colloquially. In other words, the chair will either say the laying of those charges was part of some conspiracy, long story, or it was indeed the act of a reasonable commissioner. So that's a very good example of what we're talking about. And there's no other way, with respect, Chair, in which this other counter-narrative, so to speak, can be presented to this commission without having cross-examined Mr. Gordhan. You will remember, Chair, this Chair will know this is a Constitutional Court decision in SARFU. In SARFU, two things come out of SARFU. One is that it's important for two reasons. It is a case where no less than the President Nelson Mandela, was prepared to be cross-examined. So if it's good for President Mandela, surely it's good for Mr. Gordhan. But the second issue, which was said in SARFU, was to restate the English principle that says that if a witness doesn't just have a right to cross-examine, but has a duty to do so. And because if you want a counter-narrative, as I've said, to prevail, then and you fail to cross-examine, then you have nobody else to blame, because the chair will have no option but to accept the one version, so to speak. In other words, if the chair is only given this narrative that the laying of the charges was part of the conspiracy, and Mr. Moyane fails in his duty to challenge that, then he can't later complain and say, why did the chair find that my laying of the charges was malicious? It's because you, Mr. Moyane, you were invited, you were given an opportunity, you did not take it up, and therefore the chair, what do you expect the chair to do? So that's the crucial point about the cross-examination. Now, the second, I'm sorry, Chair, if I can just finish this thought.
Yes.
The other issue, which again, maybe we were making assumptions, we don't think that Mr. Moyane, just simply from this affidavit, is just going to come and testify. Remember, Mr. Moyane has volunteered that he will give evidence, he will expand on his version. Now, one expects that that process, that whole process will involve us, it will involve the evidence leaders and so on. There might be statements that are taken and then more expansion on some of the issues. Ours at this stage is to highlight the grounds on which such cross-examination will be done. Chair, okay, I'll move to this after your question. Yeah.
If you are not going to forget the point you want to make, that's fine.
Yes. No,
you see, what I was looking for is the issue of the grounds that you're talking about. You see, my understanding of the rules is that when you apply for leave to cross-examine, you must make it clear what parts of the witness's statement or evidence you dispute.
yes.
And you must say what your version is in regard to those parts.
Yes.
So that's the main thing. Now, there's reference to the grounds. This is dealt with in Rule 3.4.
Yes.
It says an application in terms of Rule 3.3.6, which is an application for, among other things, leave to cross-examine. An application in terms of Rule 3.3.6 above must be submitted in writing to the Secretary of the Commission within, it says with, but it should be within 14 calendar days from the date of the notice referred to in Rule 3.3.
Correct.
Then it says the application must be accompanied by a statement from the implicated person responding to the witness's statement insofar as it implicates him or her.
Correct.
And then it says the statement must make it clear what parts of the witness's statement are disputed or denied and the grounds upon which those parts are disputed or denied.
Yes.
Now, you have dealt with the question of grounds,
Yes.
but it seems to me,
and the
subject
parts.
what you might say, it seems to me that when the rule says the application must be accompanied by a statement from the implicated person responding to the witness's statement insofar as it implicates him or her, it seems to me that that is the part where we expect the applicant to put up his or her version.
Yes,
So,
no, that is true, Chair.
Yes,
that is
you have
not
no problem
disputed.
with that,
Yes,
yeah.
no, I have no problem at all.
Okay.
All I'm saying is that
Yes.
that statement, it's not as if, it's not a mechanical thing where
Yes.
you must now have a separate statement. That
Yes.
statement must be incorporated in the affidavit.
Yes,
as
no,
I
no,
understand.
that's
Yes.
true, yeah.
So if we are
Yeah.
together on that, then,
Yes.
then my next submission is
Yeah.
that this is exactly what we have done, in the sense that
Yes.
we've identified, I've said, at paragraph 5, we've identified the parts. At paragraph 6, we've identified the parts. At paragraph 7, we've identified even the parts that are not clear to the naked eye, where we say they are...
The problem that I have with how that has been dealt with is that when I read it, it's not like when, for example, you do an answering affidavit,
Yes.
you know, where you
Add
say,
paragraph,
now I'm responding,
yeah.
I'm responding
Add,
to
yeah.
this allegation, it becomes clear.
The-
So, for example, when Mr. Moyane refers somewhere in his affidavit to Mr. Gordhan talking about his participation in the ITC
Yes.
issue, you know,
That's
I
clear.
don't know, I don't think I saw anything in his affidavit, may be wrong, that says, well, I did participate, but in this way and not in that way, or I did not participate at all. I might have seen, I don't
Yes.
know, I might have
It
seen
is
something
there.
that says
I'll-
he was not involved at all. or
yeah, he
something.
does, he does.
Yeah,
I'll-
maybe
I'll-
it's not put as clearly
I understand what the chair is saying.
as one wants, because part of the reason why the rules contemplate an implicated person putting up his version, it's to enable me to see the gap or between the version of the of the witness and the implicated person, how much area is disputed
Yes.
between the two statements. And that may inform also the time I set for the cross-examination.
100%, Chair. But Chair, please, I think the only problem that I have is that maybe we are moving 2 steps ahead of where we are. Where we are now, Chair, all we need to do is, as I say, almost as a grounds of appeal, is to put the grounds and make it clear that what do we contest, which we have set out in paragraph 5, 7, and 5, 6, and 7. Maybe what created the impression that the Chair is talking about is our zeal to simplify this by using the thing of themes. So we said, okay, these are the 15 things, but we're now not going to discuss each of the 15 things. We're going to put them in 5 themes to make it easier to deal with. And maybe that's trying to simplify it is what complicated it. But we did that deliberately after listing the 15 or 20 things. That's the first thing. The second thing, Chair, is that, and this is the point about maybe we are jumping a step ahead. The assumption, of course, is that there are 3 things that are going to happen before Mr. Moyane ever puts his version in the broad sense now of talking, sitting there. There'll be this application, there'll be a statement taken by the evidence leaders, or at least in conjunction with them, and then there's obviously the evidence itself that he must lead. And my humble submission, Chair, would be at the second stage, once the evidence leaders have interacted in some form, it's only then that the Chair will then say, okay, I'm giving this a day, I'm giving half a day, or whatever it is. Not necessarily now. Now, the only function for the Chair is to allow in broad principles the issue of cross-examination. Whether that cross-examination is going to be 1 minute or 10 days is not at this stage the issue before you.
Well, the approach of separating, I'll allow you just now,
Yes.
the approach of separating the issue of the grant of the
right.
grant or refusal of the leave to cross-examine and the determination of the duration of the cross-examination may be one approach of dealing with them, but I prefer to deal with all at the same time.
Fair enough.
Yeah.
That's,
So-
I accept that. There's no,
yeah.
I'm not submitting,
Yes.
Chair, that if you
Yeah.
do so, it would be
Yeah.
wrong.
No,
I'm
no,
simply
no,
saying
no,
that
yeah.
there are
But
ways of doing it.
where I think it might be important for us to look at that is the point you make, which is made in Mr. Moyane's affidavit, one of his affidavits, if not both, or even the written submissions, namely that after I've granted leave to cross-examine, if I grant it, there would be a process of taking of statements.
Yes.
I want that the statements should be in
Yes.
when I grant the
Yes.
leave, if I grant it. And as I see it, that flows from the Rule 3.4, when it says the implicated person must give
Yes.
a statement dealing with the allegations implicating him. So in other words, not just broadly, but to
Yes.
say this is my version. Yeah.
No, that I accept, Chair. Except to say this, well, at least this commission, where it has granted, or at least been willing to grant leave, the approach that has been taken, as I understand it, I read specifically the Gupta refusal,
Yes, yes.
was that the Chair actually was inclined to say, look, except for this thing of you wanting to do it overseas,
Yes,
which obviously
yes.
is not acceptable.
Yes, yes.
I'm going so far as to say,
Yes.
I will grant you
Yes.
if you remove that.
Yes,
In other words,
yes.
simply because you have been implicated, simply because you are disputing at a broad level. I don't at this stage have anything from you, Mr. Gupta, but because at a broad level you are implicated, I will grant you. And that's why we assumed, let's assume the Guptas then said, okay, we'll come back and do it. Then obviously what would follow is what we suggested. They would interact with the evidence leaders.
No, in the Gupta one, they put up their version fully.
Yes.
Yeah, in regard to the allegations that were made by the specific witnesses.
Yes, Chair.
Yeah.
But and even in the case of, what's his name, Mr. Duduzane Zuma,
Duduzane
which
Zuma.
was granted. I know,
Yeah.
I've looked at
the affidavits.
at the documents.
Yes, yes, yes.
Let me just move from this point by saying, Chair,
Yes.
I take you to page 6. Paragraph 16. So maybe one doesn't use the word version, but here's the version. We say, actually we even use the word version. At paragraph 12, yeah. Under this theme, my version is that Minister Gordhan's affidavit is more significant for what it omits than what it says. The omitted facts will give a truer picture of the commission about what actually went on behind the scenes. The truth, again, that's a way of saying my version. The truth is that Minister Gordhan was an ardent supporter of President Zuma and was in fact twice entrusted by him into what is, according to Gordhan himself, the most strategic ministry in the state capture project. It requires some exploration so as to distill its impact and meaning. Let's just pause there. Chair, anybody reading those two paragraphs would understand that Mr. Gordhan's entire posture, let me put it that way, was that he is an anti-state capture bastard or something like that. Now, the point we make here is that you cannot have that, when the version that we're going to put is that even according to the same witness, at the center of the state capture project is the Treasury, the Ministry of Finance. And actually, at a prima facie level, people are assumed to be, once they are there, whether you are Van Rooyen or Kigaba or Nene, you are a Gupta person. So, miraculously, Mr. Gordhan is the only one who is in that minister twice, appointed twice, but by no less than the person he says was the kingpin of state capture, to be in charge of this very ministry. So there's the version. Then we say, in his affidavit...
Well, what that doesn't indicate, at least as far as I recall, is it's prompted by what statement that he made that implicates
the next
Mr.
paragraph.
Moyane.
The next paragraph.
Yeah.
Next paragraph says, and this is about credibility, by the way. So in his affidavit, Mr. Gordhan seeks to downplay the impact of the history, labeling himself as an, quote, unwitting member of the cabinet, which was oblivious of what was going due to being, quote, manipulated, lied to, and abused. These two calls for exploration. Those quotes, Chair, come directly, because it's an affidavit, we don't reference them. They come literally from the mouth of, you can either say, well, we have not identified exactly where he says unwittingly, then we can find it in the record. But it does exactly what the chair says needs to be done. You put a version, your problem with it, and then you identify what he said. Now, more than that, with respect, an applicant cannot do. And then at paragraph 16, the same thing. We say, under this is the anti-Moyane bias. And bias, of course, Chair knows, is a very important issue for cross-examination. So under this, we seek to demonstrate that the levels of acrimony, hostility, and underlying hostility, because Mr. Gordhan actually used that word here, enmity and anger harbored by Minister Gordhan towards me as a person are sufficient to disqualify him as an impartial, dispassionate commentator on any issue where I'm allegedly involved. Now here, the documented and unchallenged history of racist and other forms of abuse of power in the hands of Mr. Gordhan will be provided as the basis for the conclusion postulated in the preceding paragraph. And then we refer directly in the next page, Chair.
I'm looking at you because I look at the time.
I know, Chair, I know. No, but if the Chair was... and I appreciate the engagement, by the way.
Okay.
Now, just jump to paragraph 19 then, Chair, just so that we don't waste time. Paragraph 19, you will see there that we don't just say this is our version and this is what's wrong. We take you, we say go to the affidavit annexure TMZ1, and we say go to annexure TMZ22 to this affidavit. Now, that is a version. The fact that we don't call it a version, but it's there, we actually say there's a transcript of a telephone call by Mr. Gordhan to Mr. Moyane, which Mr. Moyane found to have racist connotations and undermining towards him. For example, it's verbatim. He says to Mr. Moyane, grow up. And Mr. Moyane says, what do you mean I must grow up? I'm not a little boy. And we know the connotation in the South African context of referring to somebody as a boy. We are almost the same age. You can't talk to me like that, and so on. It's given to you, Chair, in verbatim transcript form. So where's your version? It's a TMZ1, it's a TMZ22. Then the next one, we say it's common cause. Okay, well, if it's common cause, we don't have to refer to it. So the whole thing is lettered, and even if you go to paragraph 20, we say that it's common cause that Minister Gordhan was the first ever witness called in the SARS inquiry, about which I'll talk. And then we say towards the end that these are false and self-serving claims in pursuit of the Moyane removal campaign. The undisputed evidence is that my performance by far outperformed his own. I also did not form an illegal intelligence structure, such as the rogue unit outside the parameters of the law. Well, for that you can't say, if he says it's in the negative, I did not do this, you can't say, well, where's your version? That's his version. That's what happened.
What I may have to consider is whether I shouldn't ask you to put up, to file maybe a supplementary affidavit that makes this job easier, rather than me having to try and look for them all over. If you do like an answering affidavit, you say, in his statement, paragraph so-and-so, this is what he has said, and this is what we say.
Yeah.
Or in his evidence, the transcript shows this is what he says, and this is what we say. Okay. It might make it easier.
Well, Chair,
and time saving.
Yes, thank you, Chair. Maybe in the end, but
yeah.
I would like the Chair to just give me an opportunity to demonstrate that actually is what we have done. Here's the one we were looking for, Chair, paragraph 21. We say, in further pursuance of the aforesaid vengeful and racist agenda, Gordhan has made direct accusation that I, one, improperly participated in the award of a tender of my friend, that's the one you were not sure about, if it was there, Munyeki, and two, lied to Parliament about such involvement. Okay, so that's the problem.
Yeah.
Where's the version? We then move, we say. And then it is not clear where Gordhan makes these remarks and they're not included and so on, okay. 23, in any event, I deny these accusations and will accordingly put questions to Gordhan to demonstrate their falsity. In support thereof, in support thereof, I have instructed my attorneys to obtain the necessary records of Hansard. In other words, the raw verbatim evidence of what I said in Parliament. In this regard, I will ably demonstrate that it's a case of deflection because it is Gordhan himself who secured lucrative multi-billion rand IT contracts without following proper procedures. The Commission will be referred to specific examples of such contracts and their relevant documents and so on. And then,
of course, I'm sorry. Of course,
I'm sorry, Chair.
Of course, if it's a statement not made if it's an allegation made outside of the Commission and not in his statement against Mr. Moyane and not made in the witness box in the Commission, we may have to look. Obviously,
no, it's not.
It's not.
No,
Yeah.
it's not.
So,
That allegation, Chair, is
Yes.
dealt with extensively
Yeah.
in what Mr. Gordhan attached himself in his own statement
Yes.
from page 527 to page
Yes.
598 of
Yes.
of his bundle,
Okay.
where he goes and talks about this specific contract. In the answering affidavit, he goes further
Yeah.
to say to quote chapter and verse.
it's not in the affidavit, but it's in an annexure.
No. It's in an annexure which he refers to and which he testified
Yes.
about, one.
Yes, okay.
Two, which is why I
Yes.
couldn't find it. I
Yes.
subsequently found it.
Yeah.
Secondly, in the answering affidavit, your Chair will see there may be 4 or 5 pages of quoting the Nugent findings on this very issue. So there can be no doubt whatsoever that that is the version of Mr. Gordhan.
But aren't you talking now about his answering affidavit when you refer to him quoting the
Yes,
Newton
that's
Commission?
exactly what I'm saying. I'm saying, one, you'll find it in the annexure to his affidavit in the written statement to this commission. And two, you find it even more substantiated in his answering affidavit.
Okay,
Yes.
okay,
So
okay.
there's no doubt whatsoever that it was part of this. Yeah. So again, it's exactly I mean, maybe it's a question of style, but the format is, what did he say? Where is it? What is wrong with it? What is your version? It can't be anything more than that, Chair. And then so issues of style aside, the issue is that if the chair at this stage has, there are 2 standards. One is the evidence okay, broadly speaking, relevant, as I defined earlier. Is it necessary, and does it advance the cause of the commission? And with the greatest respect, and unfortunately, this thing that I've been wanting to read, unfortunately, we couldn't get to it.
Yeah.
But we have listed there more than 10 instances of the so-called implication. Chair, let me paraphrase it because we don't have time.
Yeah.
What we're really saying is that Mr. Gordhan, the things that he implicates Mr. Moyane in, most of them amount to criminal activity, right? So let's put that aside. And if that is the case, really, then at the highest level, the only way that Mr. Moyane can defend his integrity and his rights against such accusations of just take any example of the what I term as criminal activity can but only be done in cross-examination. Now, whether the extent and all that of that cross-examination are matters that, as I say, will be determined by the chair, sometime even in the live proceedings.
Yeah.
But nobody in their right mind can say at this stage that the right to challenge someone who has implicated you in criminal activity. Let's take this example, Chair. The other side says, for example, in its heads.
Shall we agree that I give you 5 minutes and you wrap up within 5 minutes?
Yes.
I think
Okay.
it's been, we're at 10 o'clock. We should have finished everything by 10 o'clock.
I know, Chair.
Yes, okay.
Well, it's the chairs from, the questions from the chair, which I appreciate, yeah.
Yes.
But let me just make this example then. You are told, for example, in the heads, that you must take into account the so-called high-level panel report, the recent one, about the parallel state that was created at intelligence. Now, that report, incidentally, says that the people who were involved in that parallel state creation must be charged, I think, with treason, something dramatic like that. Now, here, we are saying, Mr. Moyane is saying, Mr. Gordhan was involved in exactly similar conduct in respect of the rogue unit. But the impression you are given is that the other people who did exactly the same thing must be charged with treason, but Mr. Gordhan must be given a hug, for doing the exact same thing. Now, that is a self-evident point that says that if it is true, and again, I use a big if, because we can't preempt, again, Mr. Moyane cannot also be as arrogant as Mr. Gordhan to think his version is unassailable. But if if his version is correct, then it destroys that entire, and actually you might find that it is Mr. Gordhan who must be charged with treason, because he did the exact same thing that the high-level panel says was done on a smaller scale maybe, but in a different context, but as far as the crime is concerned, it's exactly the same thing. So that's the one thing. So it's the criminal, let's call it criminal intent. The second issue, Chair, and that goes to the quotation that we make, and that deals with this issue of whether, even if it's inquisitorial, this commission. That very well-known quotation from Lord Denning,
Yes.
that says that even if it is completely inquisitorial, I'm sorry, Chair. It's at page 11 of our submissions.
Yes.
No, page 13. This is a classical quotation which has been accepted by our courts in the Dupree versus TRC matter, and I think in the Magidiwana matter, which I was involved in, that's the Marikana Commission. Because these arguments were always said that, look, and the big point, Chair, is that the standard of fairness is not the sole preserve of adversarial proceedings. Here, Lord Denning, in his typical flowery language, said, this inquiry was not a court of law. It was an investigation in the public interest, in which, like this one, in which all should surely cooperate, as they promised to do, as this one. It is true, of course, that the inspectors are not a court of law. You can put there this commission. Their proceedings are not judicial proceedings. They are not even quasi-judicial, for they decide nothing. They only investigate and report. They sit in private, but this should not lead us to minimize the significance of their task. They may, if they think fit, make findings of fact which are very damaging to those whom they name. They may accuse some, they may condemn others. They may ruin reputations or careers. Their report may lead to judicial proceedings. It may expose persons to criminal proceedings or civil actions. Seeing that their work and report may lead to such consequences, I am clearly of the opinion that the inspectors must act fairly. And all we're saying is that the fairness in this context surely must include granting somebody who has been accused, not just for reputation and careers, but of such egregious, of treason, basically, or being part thereof, of a right to cross-examination. One last point, all the references to the Nugent Commission, with the greatest respect, is completely irrelevant. This commission has got its own task, and it cannot rely, although the rules of evidence must not be applied mechanically, but it cannot rely on the opinion of another commission, no less one that is the subject of a review application by Mr. Moyane, when there is evidence of other commissions that have found otherwise, which have never been challenged. We know what the law is in relation to that. So insofar as that is made as a point, it must just be kicked out. And we make the point that most of this defense is almost 80% relying on what was said in the Nugent Commission. And to that extent, it must just be expunged and not be considered at all. All in all, Chair, what we say is that there is enough, more than enough. Even if you don't take all the allegations you make, take 4 or 5 of them and say, in principle, does Mr. Moyane have the right to cross-examine the person who implicated him, yes or no? If he does, then of course, at least, and I appreciate that the Chair says you want to do it comprehensively, then of course, we should assume that there are other procedures which must be followed to cut the cloth, as it were, to fit the commission. But there can be no doubt whatsoever in our respectful submission that the entitlement, or rather the discretion of the Chair, which is really what this is about, ought to be exercised in favor of granting that right. And I've put cases that show that a denial of, because that's what's being asked for, a denial. A denial of cross-examination is ipso facto such a serious irregularity, admittedly in court proceedings, but even in general, it would a complete blanket denial is just unfathomable.
Can I stop you now?
You can. Thank you, Chair.
Okay, let me hear.
I appreciate the engagement and the extra time.
No, thank you very much. Counsel for Mr. Gordhan.
Thank you, Chair. Good
Yes.
morning.
Morning.
Chair, I think I should emphasize 3 submissions in these oral submissions, given that we have made full written argument already. And the 3 submissions I would like to stress this morning are the following. The first is that Mr. Moyane has not laid a foundation identifying specific aspects of Minister Gordhan's evidence that he disagrees with and disputes, and the grounds for that dispute. The second submission is that the purpose on his own terms for this application is not a proper purpose for a cross-examination application. And the third is to say that if we understand the purpose of cross-examination before you by an implicated person, the application should be denied in its entirety. And let me perhaps start with that final point. Because my learned friend, I was obviously appreciative to hear, accepts that there's no automatic right to cross-examine in this commission, that it's in your discretion. What he failed to address you on, though, is the test that the regulation and the rules set for the exercise of that discretion. And there are 2 elements that must be the lodestar for any decision that you take. The first question is whether the cross-examination is necessary. And the second is whether it's in the best interests of the work of the Commission. So if we could put that a different way, is it necessary and does it progress the work of this Commission if it digresses into the issues listed in Mr. Moyane's application? And for all of the reasons submitted in the answering affidavit and in the written submissions, we would submit that it does not. Because, Chair, if we understand Mr. Moyane's application, and I'm indebted to my learned friend for identifying and stressing that the contents of paragraphs 5, 6, and 7 of the founding affidavit are what he wants to cover and the grounds on which he wants you to grant him leave to cross-examine, all of that falls into 3 categories. The first category are SARS-related issues. He wants to resuscitate the so-called rogue unit narrative. He wants to traverse his appointment and removal as the Commissioner of SARS. And he tries to attribute some motive. And I mean, the language of the founding affidavit is obviously quite extreme, if not hysterical. It talks about Minister Gordhan having a vendetta and that it's his life's work to try to remove Mr. Moyane. Of course, as the minister testified, his life's work has been to work for a non-racist, non-sexist, free South Africa. But the point is that all of these SARS-related issues are the work of the completed Nugent Commission. The Nugent Commission, and I've given you the references in the heads and in the answering affidavit at length, and we've provided you with the 2 reports of that commission headed by a very senior and distinguished judge. Judge Nugent looked at this question of the rogue unit. He looked at it and he concluded that there was nothing there, that there was no basis to say that an unlawful unit had been established within SARS. He goes at length through how the Sunday Times reports were all complete fabrications, resulting in an apology and their retraction. He goes through how the Sikakani report had been discredited, but in any event, overtaken by events. He had Judge Kroon come before him and disavow the findings of of his inquiry. And Justice Nugent looked at this issue and he said, I can see no reason why the so-called rogue unit, but of course we know it's called the high-risk investigation unit, why anyone says that it was unlawful and why Minister Gordhan should be criticized in any way for having played the small part he played in its establishment. What we then know is that Justice Nugent recommended that it be re-established. He recommended that a unit with those powers to investigate and combat the illicit trade and look at the tax affairs of politically prominent people be re-established. And we know that that's currently taking place. So all of the SARS-related issues have been dealt with by Justice Nugent. And what this application essentially amounts to with respect to the SARS allegations, you're being asked to redo or review Justice Nugent.
Well, maybe putting it like that is not accurate, but what may be accurate is to look at the same issues that he looked at, to consider the same issues.
Yes, Chair.
Or some of the issues that he considered.
Yes.
Yeah, without putting a label about review or not review.
So let's not talk about a redo or a review, but you're certainly being asked to traverse the identical terrain, and you're being asked to come to the opposite conclusion of that reached by Justice Nugent. You're being asked to find that there was an unlawful unit. Justice Nugent has found there was no such thing. So let's assume you take up this invitation to look at the same issue that Judge Nugent is finished with. Let's assume you come to a different conclusion to him. You put that in a report to the President. What is the President to do with competing reports from two commissions of inquiry that go in different directions? It's an untenable position that you're being asked to occupy. Because what you would then have to do, is expand your own terms of reference to accommodate the terms of reference of Judge Nugent's commission. And we say that all of the SARS-related issues identified by Mr. Moyane were the work of Justice Nugent's commission. He's completed that work. He has made the findings he has made. And if Mr. Moyane is unhappy with that, he has recourse. He can review that panel's findings explicitly. He has not, as far as I'm aware, done that. He's attacked the process, he's attacked decisions taken by the President on the basis of the reports issued by Justice Nugent. He has not actually, as far as I'm aware, launched a review of the Nugent Commission. And if he wants to disagree with its findings, that's the avenue he should pursue, not asking you to look at the same issues. So, Chair, on this first category of everything SARS-related, it is not irrelevant that Justice Nugent spent a lot of time and attention coming to very carefully reasoned conclusions based on a body of evidence. Then we have a category of issues that at best could be described as personality issues. The language, again, of Mr. Moyane's papers, he talks about racism, he talks about acrimony, he talks about hostility and hate and grudges and vendettas. Chair, I go back to the question that you have to answer today. Is it necessary and in the best interests of the work of this commission to entertain that? Let's assume you grant leave on those topics. Mr. Moyane's legal representatives will cross-examine Minister Gordhan about Mr. Moyane's dislike of the man. How does that help you fulfill your terms of reference? We submit that it does not. It doesn't take your work any further. And Chair, I must say that this commission, with the hundreds of millions of rands being spent on it, and the very limited time that you've been given to cover an enormous set of terms of reference, time should not be spent and money should not be spent on consoling Mr. Moyane's feelings or airing his personal grievances. It's not going to get you any closer to fulfilling your mandate. And the final category of what's in Mr. Moyane's papers is a political campaign. So it's all of these allegations about Minister Gordhan not being an angel, and Minister Gordhan actually being part of the state capture project. And as I understand my learned friend's argument this morning, somehow because he was made Minister of Finance twice, and we know that Treasury was an important target of the state capture campaign, that somehow it turns him from the man that we all know into some central architect of the state capture project. But as your questions have pointed out this morning, there's no link, there's no evidence put before you as to why Mr. Moyane says that. It's very easy to throw out allegations, very easy to throw mud and worse, and hope that something sticks to Minister Gordhan. And we understand it's election season out there. We understand the political campaign against him because he testified about what he's endured and what his family has endured. But the question is, does it help this commission? Is it necessary and in the best interests of the work of your commission to entertain what, quite frankly, are outlandish and baseless political theories about Minister Gordhan? And we would submit that that is not a way to spend the taxpayers' money and your time. So if we then look at the actual implication that was raised by the Commission's notice, the Commission identified only one item. And yes, it used the word inter alia, but it only actually identified one issue for you and for Mr. Moyane. And it's the issue of him misleading Parliament about his personal involvement in the appointment of Mr. Monyeki's firm, NICS, as a debt collection agency. It's not an ICT contract, Chair, it's a debt collection contract with SARS. The way it came up in Minister Gordhan's evidence was that he provided you with the affidavit to which he deposed in the disciplinary inquiry launched by the President against Mr. Moyane before Senior Counsel Baum. One of the charges there was that Mr. Moyane had misled Parliament. Why? Because he said to Parliament at one of its committee hearings that he had played no role in the appointment of NICS at SARS. One of the disgruntled debt collection companies launched litigation. In his answering affidavit, on oath, Mr. Moyane said, yes, I approved these contracts, including the one of NICS. So there's a competing version. You told Parliament, you played no role, you told a court, you approved their appointment. There's a discrepancy, there's a contradiction. One of them was an untrue statement. All Minister Gordhan gave you was that affidavit. He said, this is what you told Parliament, this is what we now know to be a statement you made elsewhere, there's a discrepancy. Advocate Baum was going to inquire into that. Obviously, the disciplinary fell away following it being stayed because of the High Court case, and then obviously Mr. Moyane's termination ended any need for discipline. So this NICS contract, again, has been the topic of the Nugent Commission. Justice Nugent looked at this, and we've given you the references in the papers. He looked at the issue and he said, no, Mr. Moyane was untruthful when he told Parliament he'd played no role, because he played this role of being the final approval, and he participated in that process. And Justice Nugent goes into NICS and Mahube, which is another Monyeki company, and how it all fitted together, and shared links to the allegations that were made against Mr. Makwakwa. Judge Nugent looked at all of this and made findings that there was an untruth told. So let's assume you say, no, it's necessary and in the best interests of my commission to cross-examine on the topic that Nugent has already looked at. Minister Gordhan isn't going to be able to assist you. Minister Gordhan wasn't there appointing contracts. He wasn't in Parliament making statements. So it's not going to assist the work of the Commission to cross-examine on the one issue that the Commission identified as a potential implicated issue. So again, there's no link between the evidence and what Mr. Moyane would want to cover.
To the extent that any one of the issues on which leave to cross-examine is being sought, any one or more, is or are issues that, in respect of which the Nugent Commission has made findings. To the extent that when I look, I might find that some of the issues are issues that have, in respect of which there has already been findings by the Nugent Commission. What may arise is whether Mr. Moyane is going to accept those those findings and leave the matter there, which is one thing. Another is whether he's going to challenge those findings. If he is not going to challenge those findings, the one attitude might be to say, well, if he doesn't challenge them, it means he accepts them. And if he's going to challenge them, it may be that it's not appropriate. I'm using appropriate because maybe that might be a more neutral word to use for this commission to seek to make findings on the same issue, because if he challenges those findings of the Nugent Commission involving that issue, we don't know what will happen in that review application. If he is successful and those findings are set aside, it may well be that the review court, depending on the grounds of review that may be relied upon, it may well be that the review court says, well, those findings are set aside completely, or it may be that if, for example, one of his complaints is that he was not allowed an opportunity to cross-examine, and the review court concludes that he should have been allowed the opportunity to cross-examine, it may be that the review court might say, well, I'm setting them aside and he must be given that opportunity to cross-examine. Is that one of the, are those some of the possible scenarios?
Chair, with respect, I think you've identified that there is this world of uncertainty if Mr. Moyane were to exercise his right to challenge the Nugent findings squarely, direct attack on these findings, and it may have an impact on your process and how you evaluate things. But where we stand today, on the basis of this application, I would make 3 submissions in this regard. The first is that Minister Gordhan only testified about this issue of you misled Parliament because under oath somewhere else you said the complete opposite. That's the extent of Minister Gordhan's evidence.
Yeah, you say he has no personal knowledge
No
of
personal knowledge of
anything,
any of the underlying
Yeah.
facts and events
Yes.
that led up to this appointment.
Yeah.
All the minister's evidence is about is in Parliament you said this, and that's a public record, and in an affidavit filed in court, another public record, you said the opposite. So
Yes.
there's no factual dispute that Mr. Moyane can raise with the minister's evidence,
Yeah.
because it's about Parliament transcription tells me this, affidavit copy tells me the opposite.
Yeah.
That's all he said. So cross-examining the minister isn't going to advance your process and settle that explanation. Which
Well,
brings me to my...
that might be a case where it becomes important to say, to deal with the issues, you know, sometimes you deny, sometimes you confess and avoid. To put up a version to say, well, I've seen the transcript from Parliament. It says this is what I said. That's not true. Or it is true, but the context is the following. And what is said in the affidavit is what is true.
And Chair, that leads me precisely to my second response, which is, under your rules, and it's Rule 3.3.6 in particular, that empowers you in this way, there are 3 outcomes possible today. The one is cross-examination of Minister Gordhan by Mr. Moyane's representatives. The other is Mr. Moyane testifies. And the third is somebody else testifies because somebody else can advance your work. These are the 3 outcomes because, again, the test is what's necessary and in the best interests of your commission's work. So Mr. Moyane may want to put up a version and come and testify and tell you what happened with this contract, why he told Parliament that he hadn't played a role, why he then on oath said the opposite. Mr. Moyane may be able to assist you, but his lawyers cross-examining the minister isn't going to assist on this actual dispute. And Chair, the third submission about this issue is that in the notice, the Commission identified that this question may relate to your terms of reference 1.4 and 1.9. Broadly speaking, those are the ones about government contracts. Now, again, to the extent your Commission is interested in this government contract at SARS, it's for Mr. Moyane, possibly Mr. Makwakwa, possibly some others from SARS, to come and help you to understand what happened there. Mr. Moyane's lawyers cross-examining Minister Gordhan isn't going to get you anything falling into 1.4 and 1.9. So on the only issue identified in the notice, the application would have to fail. So, Chair, what this application would actually amount to with respect to all of this SARS-related material, and quite frankly also with respect to the political and personal issues that are identified. This is an example of what we would call forum shopping, because Mr. Moyane is hoping that you'll buy what at least 5 other sets of presiding officers haven't. He's hoping that you'll do what Advocate Baum didn't do when he said it's premature for you to cross-examine at this stage. The Constitutional Court, your court, twice has refused Mr. Moyane on the basis of him having no prospects of success, where he tried to challenge and raise all of these identical issues. He's been refused twice. And then, of course, Judge Fabricius in the High Court similarly entertained these questions about whether Mr. Moyane was in fact to be vindicated and found against him. And what's important to stress, and it's in the heads of argument, when Judge Fabricius dismissed Mr. Moyane's application, challenging all of the steps taken against him that culminated in his removal, Judge Fabricius imposed a punitive costs order. And you've seen the reasoning of the judge as to why. And then the Constitutional Court confirmed that, saying you've got no prospects on appeal here.
Are there any issues relating to the application for leave to cross-examine that were the subject of that High Court judgment?
Chair, the High Court judgment, in effect, the High Court judgment was a series of declaratives and a series of mandatory relief. I don't have the notice of motion with me, but what it essentially was about is, draw a line through the Nugent reports. The President mustn't have any reliance on those reports and take any decisions to suspend and ultimately terminate me on the basis of them. I should be allowed to come and make my submissions in the way I see fit, and you can't take any action against me until that's all ventilated. By implication, when the Constitutional Court turned down that case when it was tried to be brought as a case of first instance, and then when it confirmed the High Court's rejection of these arguments, the Constitutional Court is saying Judge Nugent's process was proper, and the President's reliance on that process, the decisions he took, suspension, disciplinary before Advocate Baum, and the removal.
Yes, but my question
legitimate.
is, are there issues relating to the application for leave to cross-examine that were covered by the High Court judgment?
Chair, the process of Nugent, we would say, was the subject of those cases.
Yes.
Obviously, there was one declarator sought against Minister Gordhan. That declarator is the one that the Constitutional Court rejected twice.
Yes.
It was the declarator that said Minister Gordhan should not have played the role of deposing to the affidavit that set out the charges against him.
Yes.
That was the declarator sought against the minister.
Yes.
The reasons given in the court papers, which are attached to this application, the reasons given were the same thing. Minister Gordhan doesn't like me, he's been racist towards me, the transcript of the phone call was attached.
I didn't see the High Court judgment here. I would like to have a look at it to the extent that it may enlighten me on any issues that may or may not be relevant.
Chair, I'm sure we can
Okay, yeah, arrangements
arrange
can
that
be
that
made
finds its
after
way to
today.
you.
Yeah, okay.
But we would just say that there were two aspects that were the same in the litigation strategy followed and what's before you now. The basis for all of the declaratory relief sought against Minister Gordhan is the same. It may not be an exact mirror image in terms of the precision, but I know that the transcript of the phone call was there, the accusations about dislike and vendettas and grudges and acrimony and bias and all of those allegations from Mr. Moyane's personal view, those were all ventilated there. Chair, the other important issue...
It may well be,
yes.
it may well be that I don't know how thick the High Court papers were. It may well be that I should have them available should I want to have a look at what was placed before the High Court by the parties and what was placed before the Constitutional Court by the parties. It may be that it's not worth it, but it might be that if I want to have a look, I should be able to have a look.
Yes, yeah, I'm sure we can get the full set of those papers to you. And I would just highlight again that the High Court, confirmed by the Constitutional Court, imposed a punitive costs order because it said that the way those proceedings were run, and we've quoted the paragraph in our heads of argument, it's all strikingly similar to the invective and the bile that you see in the papers here against Minister Gordhan. So what this application is trying to do is hoping to sell you on something that Advocate Baum, Judge Nugent, Judge Fabricius, and the Constitutional Court twice have said this is not an appropriate use of the process.
And you need to also make sure I know what the first application to the Constitutional Court was about, what the second one was about, so that I have a complete picture, because otherwise I just hear that this was dismissed, but I don't know exactly what it was. Yeah.
Yes.
Okay.
Chair, very briefly, they went straight to the Constitutional Court with a Part A to pause everything, essentially. Part B was a whole lot of declaratives about the processes followed. That included the one about Minister Gordhan and the affidavit. And the grounds for that declarator are similar to the personal and political attacks here.
Yeah.
Concourt rejected those. Then he went to the High Court, Judge Fabricius dismissed. Then they went back on appeal to try to have essentially Part B decided at the same time. The Concourt rejected again, including the confirmation of the punitive costs order for having done this. Because, Chair, Mr. Moyane...
So if I could have the whole thing.
I'm sure we can...
I don't want to make one decision and find afterwards that had I had access to all of that, maybe I might have dealt with the matter
Chair, I'm sure we
differently.
can get you all the papers, the two Constitutional Court orders, as well as the High Court's order.
Yes.
Because, Chair, where all of this goes is Mr. Moyane very explicitly tells you that he's here to rehabilitate his reputation and career prospects. He's asking for your help to rehabilitate his discredited name. And when you read the Nugent reports, when you read Judge Fabricius's decision, what you'll see is the grounds on which Mr. Moyane has been discredited and disgraced. So he comes to you asking for rehabilitation. But again, rehabilitation is not the purpose of this commission. He has a legal avenue he can take. He can take these things on review. He can't come to you asking you to help him rehabilitate his name and his career prospects. That's not within your terms of reference, and it's not a useful expenditure of public resources. So if we then look at the other factual issue that was ever raised in this case, it's this whole issue about the criminal charges. So initially there was some confusion because it seemed that Mr. Moyane denied being the complainant. It was clarified in reply that he just said, no, I did it as a reasonable SARS commissioner and anyone in my position would have done the same thing and it wasn't out of malice. Chair, on that, Mr. Moyane's motivations are not relevant. They're not going to help you in your work to understand why he did it. Because let's remember what the minister's evidence in this regard was. He said, I was reappointed following the then president's reversal of his appointment of Mr. Van Rooyen as Minister of Finance. From the moment I arrived, it appeared as if there was then regret at the fact that I was back. And I then endured a campaign, 27 questions, the charges, the political campaign, the social media campaign, which of course continues in various forms to this day against Minister Gordhan. That was his evidence. So Mr. Moyane coming and saying, I was a reasonable person when I went and filed charges, isn't meeting the evidence. It doesn't implicate Mr. Moyane's motives. So it's not actually an issue on which Mr. Moyane must vindicate some right as an implicated person. The fact is he was the complainant, as he now has clarified. The fact is that Minister Gordhan's evidence was that it was one instance of this pressure and this campaign and what I had to endure. So why the charges were brought?
Assuming that it is an issue that I should entertain, his motive may be relevant. If Mr. Gordhan's evidence was to the effect or suggested that in laying the complaint against him, Mr. Moyane knew that there was really no case, but he was doing so for ulterior motives.
Chair, let me say two things in response to that. The first is, again, Judge Nugent has looked at this. Judge Nugent has looked at this and said, Mr. Moyane arrives, Minister Gordhan gets appointed, these charges are brought, they're baseless, they're withdrawn, it's all rather suspicious and seems to have been politically motivated. So Justice Nugent has looked at this. The second point is this. If you decide that Mr. Moyane's motivations to file charges, to file a complaint that ultimately led to charges against the minister is relevant, necessary, and in the best interest of the work of the Commission, then again, Mr. Moyane should come and tell you about his motives and be subject to cross-examination on those motives and test his theory about why he says it was reasonable to do what he did. It doesn't help to cross-examine the minister about Mr. Moyane's mindset.
Well, if the minister, in giving evidence, suggested that there was an ulterior motive on the part of Mr. Moyane in laying those charges, then there should be nothing wrong with the minister being cross-examined on whether his attribution of that motive to Mr. Moyane is correct or justified. But that is if I were to accept that the issue is one that should be dealt with here.
With respect, correct, Chair. So let's go back. Is it necessary and in the best interest of your work to delve into this question? We would submit not. If you were going to, the minister has testified and said, this was the campaign that I endured and the charges were one element of it, and my perception is that it was a political campaign. Mr. Moyane's cross-examination saying, no, I was just being a sensible commissioner, there's no factual dispute that cross-examination resolves for you. It's not like I was at Saxonwold, no, I wasn't. Factual dispute, cross-examine, come up with evidence, and it takes your commission forward because you establish some facts. This is two people who disagree about why something happened, and both of them can be right. One can say, I was just being sensible in laying charges, and the minister says, I endured a campaign and I saw this as part of it. It doesn't help your job.
Well, the one may be saying the motive for this one doing this is part of state capture, and the other one might be saying it's not part of state capture, it's just a bona fide decision that any citizen would have taken, any citizen in my position would have taken.
And, Chair,
and once we go to that level, then I would have to say, well, because I need to establish people who were participants in conduct that may constitute state capture. But again, that is if that issue is an issue that I entertain. But I think you have made the points you wanted to make on that. You may be ready to go to the next point.
Yes, and Chair,
Yeah.
let me just say finally on this point that, again, and it arises out of the questions you posed to my learned friend this morning. Mr. Moyane needs to put up a version
Yeah.
that can be tested. So even if you did think that this would advance your work, and for all the reasons I've already explained, it doesn't. But if you were inclined to entertain it, you need a version from Mr. Moyane first in order to test, which we simply don't have. So, Chair, finally, let me conclude by saying that the Minister has nothing to hide from this Commission. The Minister, as he has repeatedly said, is willing to assist you. If there's further information that you require from him, he will come and continue to assist and support the important work of this Commission. But the reason why he is opposing this application is because it's either airing personal vendettas and grievances, which are not part of your terms of reference and don't advance your work, or it's part of some political campaign and the reliance, the explicit association of Mr. Moyane with the narrative run by certain political opponents of the Minister in his papers by attaching their papers shows you that there is a political element to this, that they're trying to introduce into your proceedings. And finally, everything SARS related has been dealt with by Justice Nugent. So on the three things they want to try to do here, we would submit it is not necessary and it's not in the best interests of the work of the Commission to do that. And it's the best interests of the Commission for another reason. Because this kind of abuse of your process, which is what we would say this would allow, that's a reason why people won't come and take up your invitation to come and give you information. If they have to endure their political detractors and people that used to work with them being able to come and air personal grievances, why would anyone put themselves before you? Why would you put yourself through that? So there's a chilling effect that is possible on the Commission here. And so when you're thinking through, is it necessary and is it in the best interests of the Commission, entertaining this application is likely to have a detrimental effect on the willingness of participation in this Commission. And given that you have very little time left, if we actually look at the calendar and what's left to do, we would submit that it would not be the best use of your public resources. Chair, other than if there are any other questions, those were our submissions.
Thank you. Mr. Mpofu, I don't know whether Mr. Pretorius wants to say anything for 5 minutes or he wants to come after you. Okay.
Thank you, Chair.
This time I'll be strict with
I know.
you. Yeah.
To the
So,
10 or 15
any
minutes.
reason to give you more than 7 minutes?
Yes, Chair, because we agreed on 10, which I wanted to increase, but I'm happy, I'm happy with the 10. Yeah. No, Chair, I'll be very quick. Yeah.
Very brief. Yeah.
Well, Chair, I mean, really, I think that I just want to highlight those issues over which there's an attempt to pull the wool over the eyes of this Commission. One, anybody who says, we simply don't have, my learned friend just said, we simply don't have a version as to whether Mr. Moyane was bona fide, the debate that you just had. What? We have attached the Skakane report. We have referred to the Kroon report. We have referred to the KPMG report. We have referred to the IGI, Inspector General report, all of which say that Mr. Gordhan's activities were unlawful or criminal. So to say there's no version is just, the only counter version is that of the Nugent Commission, which we have said, Chair, explicitly in our replying affidavit, we are challenging in court. So the Chair, with respect, said if he's going to, it's not if, he has said under oath that he's going to challenge that. It's part B. My learned friend says that it was all these court cases she refers to were part A. So it's disingenuous with respect to then think that part B has just disappeared into the ether. Because the Part B is still alive, and Mr. Moyane tells you, Chair, in this application that he even says, I'm taking advice whether I should pursue Part B as it was or issue a fresh challenge to the Nugent review, report, because now remember there's a final report, so it might go wider than whatever he was contemplating last year. But he says, one thing I can tell you, Chair, is that I am going to review this, and we're still within the time within which that is going to be done. There's no doubt about that. There can't be any doubt in the mind of any lawyer. Now, and my learned friend says, Part B says you must draw a line through the Nugent report. So what is that? If it's not a review, draw a line through the report. That means you, Chair, should not consider that report because, and we don't want to talk about prospects of success or whatever, 50-50, leave it at 50-50. 50% it might stay, 50% it might be set aside. That's all the Chair has to take into account. And therefore, to suggest that this commission can rely, even if it was not being challenged for that matter, when there are 4 other reports which have never been challenged by maybe 20 people, and then 1 report which is being challenged by 3 or 4 other people. I mean, it's actually a racist attack on this commission to suggest that this commission must suddenly, ukhulumilu Nugent. There's no such thing. The Nugent report has got the same status as any other report. And the other reports of Sikakan and other people which have never been challenged, even though Mr. Gordhan, let's take the Kron thing, for example. Kron J. They come here and say Kron J disowned his report. That panel had about 7 people. If one of them disowns the report, who cares? Because it might well have been that the report in any event was 5-2 or 4-3 or 6-1 or whatever, we don't know. The report stands. Nobody has ever discredited it. Nobody has ever reviewed it. And it says that Gordhan should be investigated for criminal charges, or rather, no, that is the IGI report. But it says it was unlawful, and so does Kakan, and so does KPMG, and so on. So this is just trying to mislead this. And I'm glad the Chair has asked for the papers, because the other red herring is this thing, oh no, there have been these court cases. Though all those court cases I know because I drafted them. All those cases, the first one was about whether there was direct access. The Constitutional Court made it clear. It says you may go to another court. So what has that got to do with the price of milk? It has nothing to do with the merits. It said you must go to the High Court. That's just one example. The other one, it said no prospects of success on Part A, and the Chair will know there may be an array of reasons. For example, the fact that it was only an interim finding that is being attacked and so on. So all that is just to confuse, to at least an attempt to confuse this court, and the Chair will clear it out when he gets the necessary copies. The other red herring, oh no, Mr. Moyane, now that he has lost these cases, wants you, Chair, to rehabilitate him and so on. I can't say it in open court what I think of that submission, because the sequence of events is very clear. When Mr. Moyane came here, Chair, in front of you, I came here on the 19th or 20th of November and said, we are applying to cross-examine. None of these judgments that my learned friend is talking about were out at that stage, 0. So how could it be that we are motivated by those judgments which had not happened when I was standing right here on this podium saying that we are going to ask for cross-examination? That's just an attempt to obfuscate the issues. Then we're told that it's hysterical to suggest that there was a vendetta by Mr. Gordhan. Well, the funniest thing is that at page 390 and 91, Mr. Gordhan says, and I'm not sure if the pagination works, at 12.3, Mr. Moyane using the platform to denigrate and me and my record public service through cross-examination by his legal representatives, utilizing outlandish theories, a racist and populist script, and in the pursuit of a personal vendetta against me. So if it's hysterical to say Mr. Moyane has a personal vendetta against him, why is it not hysterical in this case? What's so special about him? So and he can accuse people of racism. And by the way, Chair, with the greatest respect, if nothing else you remember that I say on this point is this. In the papers, you'll see that there's a specific reference to the racism issue. There are even transcripts and so on. Mr. Gordhan, who was cited, did not oppose, never filed a single affidavit in those cases. When you receive the papers, you'll see, to say, Mr. Moyane, for 3 or 4 pages, says I was racist against him, he says I was calling him a boy, he says I was condescending towards him, he said I was denigrating, I humiliated him, I insulted his dignity, and I say he's wrong. 0, till today. He has never, a person who's accused of such serious issues as racism in the context of South Africa would have just put even a 1-page affidavit to say, look, I don't want to get involved in the employment issues, but I just want to put on the record that I'm not a racist, I never called him a boy, he's making it up. The transcript is wrong, it was manufactured and doctored somewhere. Never. So those are the facts. But the last point, Chair, is what the Chair put to my learned friend, which, as far as I'm concerned, decides the issue. The issue is this. If Mr. Gordhan, in his wisdom, sat here, and Mr. Pretorius, no less than Mr. Pretorius, put this to Mr. Gordhan, which is the discussion, your Chair, you were having. At page 56 of 115 of the transcript of Mr. Gordhan's evidence. This is the whole thing about the laying of the charges by Mr. Moyane and the 27 questions, what have you, which went at length. Says Mr. Pretorius, is there not an argument that could be put to you that these were genuine investigation in relation to matters of potential unlawful activity? There's a point that the Chair was making, that if there's a counter-narrative, and then Mr. Gordhan gave some long, convoluted answer which did not deal with that. But that shows exactly, the only reason Mr. Pretorius would have asked that question is because it would be relevant as to the motive that was being attributed to Mr. Moyane by Mr. Gordhan, which Mr. Moyane disputes as being, and if that is not a question for cross-examination, then nothing is. Because cross-examination as to motive, let alone the questions of bias, is legitimate. So even on that narrow issue, there is no doubt, but no doubt, Chair, that the issue of cross-examination should be given. And my learned friend maybe was not listening. I did articulate the test of necessity and mandate. And I said, I use the word mandate deliberately because it's the wider test. It says, is it necessary, 1, and does it advance the mandate of the Commission? Because that's how it has been, it's articulated, I think, in Rule 6.1. The point we simply want to make is that it is, if anything is going to can discredit this Commission, it is the idea, obnoxious as it is, that is being suggested here, that it is acceptable for Mr. Gordhan, who is the boss, to come here and denigrate Mr. Moyane and cast aspersions on his character and his motives. But it is not acceptable for Mr. Moyane, the subordinate, to come here and defend himself against that and also to assert issues which are relevant to state capture on the part of Mr. Gordhan. That is the most ridiculous submission I've ever heard in my life. Because if that is what this Commission is going to be communicating to the world out there, that you can be denigrated, you can be called all this and the other, but you will not be given an opportunity to put your side of the story. That's what will discourage people from coming here. Not granting what is the obvious right of Mr. Moyane to refute the disparaging remarks and the criminal imputations which have been put upon him. I'm sorry, Chair. I'm so sorry. 2 seconds.
Okay.
This is just a reference. I
Yes.
won't even motivate.
Yes.
In the invitation of the Commission to
Rule
us,
3.3 notice.
The 3-3 notice, that's correct, Chair.
Yeah.
On my pagination, it starts at page 270. I'm told, Mr. Pretorius tells me that our pagination also appears, so even if it's wrong, ours would be the Koki pen one.
Okay.
Yes.
Okay.
So 271 of the Koki pen, pagination. Paragraph 4, Chair, I just wanted to highlight that.
Yes.
To say, the commission said, so we don't even have to come and say to you, Chair, this is how it's relevant in terms of the terms of reference. The commission says to us, you are implicated in the following ways, inter alia, blah, blah, blah. And then it says, these allegations fall within the investigation of the commission as envisaged in its terms of reference, and in particular paragraphs 1.4 and 1.9 thereof. Case closed.
I just want to say that I look at that what is put there in a Rule 3.3 notice is the legal team's view on the position as opposed necessarily of the chairperson.
Yes, sir. No, Chair.
Usually I have not even seen the statement by the
No, Chair, I think that's an important, we spoke about it in
Yes,
chambers.
yeah, we do,
No, it's very
yeah,
important.
yeah,
We don't at all
Yeah.
impute any of these utterances to the
Yes,
Chair.
yeah.
As I said in chambers, we
Yes.
regard it as, in the High Court analogy,
registrar,
as if they
yeah.
come from the registrar.
Yeah,
In
yeah.
other words, but all of the point I'm simply making is that
Yeah.
the
That's how it
evidence
was seen,
leaders,
yeah.
highly trained lawyers, senior
Yeah.
counsel, and so on, if they say the allegations we're talking about above relate to terms of reference 1.4 and
Yes.
1.9,
Yeah.
at least
It
that
is
must count for
yeah.
something. Yeah.
Okay.
As court, please.
Thank you.
I'm sorry. I mean, as the
Thank you,
commission,
Mr.
please.
Mpofu. Thank you, Mr. Mpofu.
I'm indebted.
Mr. Pretorius, you wanted to say something? I'm sorry, Ms. Ru wants to say
Sorry, Chair, I just need to correct something on the record.
Yes.
The reason why Minister Gordhan has not put in an affidavit contradicting the racism allegations in the court papers is because the Constitutional Court dismissed the case on both occasions before giving him an opportunity to do that. I just needed
Okay.
to correct that on the record.
Okay, thank you.
I'm sorry, Chair. No, that's not true. Mr. Gordhan was cited in the Constitutional Court, yes. What then happened, because the Constitutional Court referred the matter back to the High Court, Chair, we then complied with the Constitutional Court directive. And that's how the High Court Part A matter happened. When that happened, Mr. Gordhan did not oppose there as well. If the Constitutional Court did something before he moved, which is also not true, then at least he should have opposed
But,
in the High Court. I'm
yeah.
simply saying the sequence
Okay,
is
but
wrong.
in the end, really, it's neither here nor there for these purposes. Yeah.
But that
Okay.
correction is wrong.
All right. Mr. Pretorius.
Thank you, Chair. We would like to place before you several points.
And 5 minutes for you. You had indicated 5 minutes should be enough.
Well, as long as our treatment is consistent.
They didn't ask for 5 minutes.
Yes,
You asked for 5 minutes.
This will not be included in the 5 minutes, Chair.
Okay, all right.
The first is, what is the proper approach to applications of this sort? And our submission in that regard, Chair, is that the approach cannot be based on a right to cross-examination, because that is not present in these proceedings.
That's common cause now.
The applicant must establish, firstly, that he is implicated by evidence. Secondly, that he has a version on the basis of which that evidence may be contradicted. And thirdly, and importantly, Chair, that it would further the investigation of the Commission to allow that cross-examination, or, and we stress, or be necessary to protect the integrity or reputation of the person wishing to cross-examine in respect of that evidence or issue. Based on that, Chair, if one has regard to paragraph 13 of the applicant's submissions, our view is that 13.5, 13.8, 13.9 and 13.10 may, subject to your discretion, if you believe it would further the objects of the Commission and its investigations in its investigatorial role, or seek to protect the integrity and reputation of the witness. Those are the four which we concede may. It's 13.5,
Yes,
13.8,
yeah,
13.9, and 13.10. The next point, briefly put, Chair, is it's not within the province of cross-examination or the cross-examiner of a particular witness to open an avenue of investigative inquiry. It is for the Chair to direct what evidence may be put before it and what other avenues of inquiry may be opened. So it's not for the applicant to conduct his own investigation via cross-examination. Differently if that evidence is brought to the Commission via the legal team. That's a different question. Then, Chair, the IGI report, which appears at page 315 of the papers, that's the Inspector General of Intelligence. That is a classified report. It has not been declassified, although there is mention of it appearing before some or other forum. You may want to consider, Chair, whether when the documents before you are released for publication by the press, that report should be included or excluded from the documentation publicly released.
well, if it's classified and it has not been declassified, it shouldn't be for public consumption.
Correct.
And I don't even know whether it should be here.
Well, it is here, unfortunately, Chair, but the fact that protocol may have been breached by putting it before you, I have no facts to suggest that it has,
Yeah.
but does not excuse the Commission from adhering to its own protocols in controlling public release of classified documents.
Well, I may have, I see Mr. Mpofu wants to say something. I may have to say that it should not be published before the end of these proceedings. It should not be published unless I make another decision at some stage in the future.
As you please, Chair. The last issue, which hasn't really been dealt with by the parties, is what time, should you, in your discretion, Chair, wish to allow cross-examination on any particular topic or subject to any particular conditions, what time should be afforded. And in that respect, what we wish to place before you, Chair, is that the calendar of the Commission at present and its time limits place great pressure. We have 250 witnesses at least to call before the end of the year. That doesn't include implicated parties, nor does it include time for cross-examination. And I think the parties must accept that their expectations may have to be tempered by that consideration.
I think Mr. Mpofu made it clear that they accept that they were, if leave to cross-examine is granted, there would be a limit put by the chairperson on the duration. Of course, we haven't gotten into the question of how much time. Yes. In the past, I have, in regard to those who have cross-examined, I think I had given them 30 minutes and they accepted that, and they worked more or less within that. They may have exceeded a little bit, but it would all depend, because also there it was the issues that I considered. So in every case, in determining the amount of time I would grant, I would look at the issues. That's why it's so important to have the version of both parties or both persons involved, so that in deciding on the amount of time I allow, I have a fair idea of how much difference there is in their respective versions. But that's something that one can deal with.
Thank you, Chair. Those are the points we wish to raise. Mr. Mpofu is welcome to enjoy the last minute of my 5.
Yes. 2 seconds only, Mr. Bofu.
Yes, TCJ, two seconds. The first one is the second point, TCJ, we accept that there will be limitations. Of course, subject to the caveat that Mr. Gordhan was allowed to go on for days and about his daughters and all that. But we accept that not all that was about Mr. Moyane.
Yeah.
And therefore, it will have to be curtailed. But on a more serious issue, which is the IGI report, Chair. Well, Chair, again, another caveat. Mr. Gordhan's version, of course, is that this might be a fake report. So if it's a fake report, it can be classified. So, but be that as it may, because it's not a fake report, we accept that what Mr. Pretorius proposes, even on the off chance that it's a genuinely classified report, it would be improper to put it for public consumption. We must make the point, of course, that when we had it here, we had it in the context of papers which are already in the public domain in the Equality Court of a matter that I think was initiated by Mr. Gordhan himself. And so it's already in the High Court, it's already here, but as far as this commission is concerned, we accept that it would be improper to, or rather it may be redacted when the papers are released.
Okay, thank you. I will reserve my decision on the application, but in the meantime, I want to say that the IGI report is not to be published unless I decide differently at a later stage. So in regard to this application, I've reserved my decision, and I may ask the parties to deal with any other issues that may arise when I look at the matter before I make my decision. Okay. What is the next
Chair,
question?
there are 5 minutes.
Yeah, let's
One
see.
of those minutes in relation to the application by Mr. Abrams.
Yes, let's do
He has
that.
applied for condonation for
Yes.
the late filing of a statement, which will in due course be put before you, Chair. The application is before you. I have
And
a
it's
copy here.
unopposed.
It's unopposed,
I have
and we bring
read
it on
it.
behalf of Mr. Abrams.
I have read it, and condonation is granted.
Thank you, Chair.
Is there another matter to be dealt with before we
No,
go
Chair.
into witnesses? No. Okay. I think then we should take the tea adjournment, and then we'll resume at 11:30.
Thank you, Chair.
We adjourn. Yes, Mr. Pretorius.
Yes, Chair, before the ESCOM evidence resumes, there's one witness that is to be interposed, and that's Ms. Ngabadele, who will be led by Ms. Sello.
Yes, okay, thank you. Good morning, Ms. Ngabadele.
Chairperson.
Thank you.
Thank you, Chair. Chair, before we swear in Mrs. Ngabadele, for record-keeping purposes, we've made available to you a little file we marked Exhibit D8.
Hang on 1 second. I still
It's a
have here
ring
things
bound.
that belong to what we were doing earlier.
Yes, Chair.
I think this relates to Mr. Sean Abraham's condonation application, and it should get out of the way. Also,
It should be a ring-bound document.
Mr. Moyane's application and Mr. Gordhan's opposing affidavits and their submissions should get out of the way. Got Exhibit D8.
Thank you, Chair. We have marked it D8, Chair, in anticipation that the Chair will approve. If the Chair will recall, Ms. Mentor's range is D for David, and
Yes.
so far the exhibits go to 7A and 7B, being the video recordings of the inspection in loco.
Yes.
So we would, with your approval, then, Chair, request that be marked D8.
It shall be so marked.
Thank you, Chair. D8, Chair, has actually got statements of two witnesses. The first statement relates to Mrs. Klengiwe Ngabadele, who's the witness in the box now.
Yes.
The other statement we shall deal with in the fullness of time.
Yes.
With that, Chair, then may I request that the witness be sworn in?
Yes, okay, thank you.
Please state your full names for the record.
My name is Klengiwe Ngabadele.
Do you have any objections to taking the prescribed oath?
Not at all.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you.
Thank you, Chair.
You
Chair.
may proceed.
Just to give perspective to Mrs. Ngabadele's evidence, the Chair will recall that Ms. Mentor, during the course of her testimony, indicated that after she was offered the ministerial position by Mr. Ajay Gupta, she had a conversation with Mrs. Ngabadele at which she disclosed this fact to Mrs. Ngabadele. Mrs. Ngabadele has prepared a statement in response to that one particular issue and is present here today to testify on that.
Actually, if I recall correctly, and I got reminded when I was looking at this, is that Ms. Mentor said she made 2 or 3 calls, maybe 3 calls to, oh no, that was
The
to
other
her
one.
friend, Ms. Nkosi, is it Nkosi?
Yes, it is. Chair.
Oh yeah, that's the one. Oh,
That,
there's only one in regard to Ms. Mhlabeli.
Only
The
one in
oh,
regard
yeah.
to Mrs. Ngabadele.
Okay, all right.
And again, perhaps some perspective would assist here. The Chair would recall that in her original statement at paragraphs 103 and 104, Ms. Mentor had initially stated that she made this disclosure to Mrs. Ngabadele, Mr. Bloom, and Mr. Gwele. In her subsequent appearance on the 12th of August, she noted to the chair that she had made an error, and she changed her position to say that the discussion she had with Mrs. Mugabadeli was between the two of them. The statement filed today is in response to the amended version of
Yes.
that incident. Thank
Okay,
you.
thank you.
Mrs. Mugabadeli, I see you have it already. Exhibit D8. Could you please turn to page HCM 01? It's a document that runs on for 3 pages until HCM 03.
Yes.
Is that your statement you have made to this commission? Do you confirm?
Yes, this is my statement.
And at page HCM 03, the signature appearing thereon, is that your signature?
Definitely, that's my signature.
Do you confirm the correctness and do you stand by the allegations you make in this statement under oath?
Very correct.
Thank you. Ms. Mugabadeli, just very briefly state to the chair, give the chair your background, very briefly, including your time of service in Parliament.
If you say background, how far back do you want my background?
Okay, that's a good question. Maybe adult background. Perhaps you start off by mentioning that you are a member of the ANC, and perhaps you take it from your membership of the ANC leading on to your service in Parliament.
Otherwise, you can just say, when did you start as a member of Parliament? And which party were you representing in Parliament?
Just like my father was a member of the African National Congress, I was born within the family of the African National Congress. So since I grew up, I went to Parliament in 2004, April. I don't know whether I want me to reverse.
And you remained a member of Parliament until 2014?
Until 2014 June.
Okay. And during that time, you were a member of certain portfolio committees, is that right?
A number of
A number of them.
committees, yes.
Was the Public Enterprises Portfolio Committee one of them?
I've never been that one.
Or maybe it was called something else
No,
at that
Chair,
time.
if I may,
Yeah,
the
yeah.
right committee is the Joint Standing Committee on Intelligence.
Oh, the joint, yeah.
You
Oh,
served on that.
Ms. Mento was chair of the
Of
one
the-
for public
indeed, Chair.
enterprises, but she was also serving.
Both
Yes,
served on that
yes,
committee.
Oh,
Both
both
serving
served on
the-
that
yes.
one.
On the
Oh,
joint
okay,
standing.
all right, yes.
Oh,
You
so-
continue.
I can
You
give
may
you some of the committees that I served on.
I guess for completeness, you might as well, if you recall. Then.
I served on the education one, Public Service and Commission, Defense, Joint Standing Committee on Defense, Joint Standing Committee on Intelligence. I'll leave the other ones.
Okay.
Then I was appointed to some commission, one commission, if you remember when the soldiers were marching to union buildings, I was in that interim commission, 2 ladies only in that commission. And I was also in the committee that was dealing with the protection of information and others that were short-term.
Okay.
Thank you.
Now, specifically in respect of the Joint Standing Committee on Intelligence, you served on that committee with Ms. Mento, your statement
I
said.
serve in the committee with Ms. Mento, yes.
Besides that relationship, do you know Ms. Mento personally, and could you just briefly state to the chair how you know Ms. Mento?
Yes, I do. Besides serving in the Committee of Joint Standing Committee on Intelligence, we're both sitting in the caucus, the ANC caucus. And she was my neighbor when I arrived. I found her in 2004, having arrived in 1999, if I'm not mistaken. So I joined in that parliamentary village, and I was her neighbor. We had children. I was raising my sister's children, and they would help one another and each other on homework and stuff like that. We'll go, I love art, she loves art. We'll discuss so many things if I remember of an ANC, let me not talk about other parties. If I remember of the ANC, you like discussing about the past, the present, and what you had hoped to achieve and what is being achieved and all those stories. Indeed, yes. We used to discuss a lot with Ms. Mento. And her children were just equivalent to my own children. Same with my nieces and nephews. So it's not a person I can say she was at a distance with. We're very close.
You are very close.
We're very close, very
Okay.
close.
Okay. Thank you.
And in 2010, the relationship was as you have just described, during the year 2010.
In the precinct of Parliament, yes. But I don't actually remember when Ms. Mento moved away from being my neighbor. But
Or
yes,
at a certain stage,
At a certain
you were not
stage-
neighbors in the parliamentary village.
yes, yes.
Okay.
The Acacia Park is very big. There is a part that is lower down, very far away from, I'm at the entrance next to the gate. So she moved and recycled further down, which was very, very far away from me, up until I left Parliament in 2014. At that time, that relationship of after working hours and discussing things was no longer there because it was too far.
Okay. Now, as you will recall, you were provided with firstly Ms. Mento's statements, then the transcripts of Ms. Mento's testimony, and you were asked to comment on an allegation made by Ms. Mento, and for this purpose, I'll refer you to paragraph 6, where a quote is given with reference to the transcript, that at page 67 of the transcript, dated 12 February 2019, from line 13 to 15, Ms. Mento states as follows: I have said also to the legal team of the commission, I may have discussed it with Mrs. Mgabadeli, may be able to corroborate. Well, it goes further. I also said that the SS member of the Standing Committee on Intelligence. That is a direct quote taken from the transcript. Please concentrate on the first part because that is the relevant part as to what she says she may have discussed with you. My question is, Ms. Mento's evidence is sometime in between September and October. Mr. Ajay Gupta offered her a ministerial post. And at the conclusion of this conversation, the then president, Mr. Zuma, joined them in a room and she disclosed this fact to him, to which he did not respond. That is Ms. Mento's testimony to the chair. Did you have a conversation such as described by Ms. Mento in the transcript, or concerning a offer made to her by Mr. Ajay Gupta?
I think maybe let's add a part of her version that you have left out that may be important, namely that she says she had traveled from Cape Town to Johannesburg to meet the former president, President Zuma, but she ended up at the Gupta residence where she says she had a conversation with, I can't remember whether she's specific that it was Ajay Gupta or one or other of the Gupta brothers who offered her the position of being Minister of Public Enterprises on a certain condition that she mentioned. I think it was that on condition that once she was Minister of Public Enterprises, she would terminate the airline route from Johannesburg to, is it Mumbai?
Mumbai.
To Mumbai. And while she was having this discussion with Mr. Ajay Gupta, or whichever of the Gupta brothers, the former president emerged, this is now at the Gupta residence, emerged from one of the rooms, and he, at this time she was getting emotional, that's her version, because she was very shocked by this offer from the Guptas, and the president calmed her down and walked her to the car to go back to the airport. So I just want you to get as full a version of what that part of the story is, because I don't know which part may or may not have stayed in your memory if there was such a discussion, and what would have made you to remember the discussion easily, if at all you remember it. Ms. Selo, have I captured it properly?
As far as Ms. Mentor's testimony in totality is concerned, yes, Chair.
Yes. So that's what she told the commission, and she said, she either said she discussed it with you, or she may have said she thought she had discussed it with you, among other people that she said she had discussed it with. And the purpose of calling you is to see whether you have any recollection of such a discussion.
Chairperson, all the details that you are giving me now, I learned about them just like most of other South Africans when Feki Mentor was here. And the Feki that I know was not going not to tell me when she is being called. As I've given you the background, how close we were and were still, because when I get time, up until this commission started, we do phone each other and one another. I would have no reason why I should say I don't recall her telling me. And fortunately herself, on paragraph 6, she said, I may have discussed it with Mrs. Mkabatili. So I learned about all the calling by the president and whatever from watching the television when the state capture was in space.
The commission was sitting and she was giving evidence.
Yes, and all the descriptions of whatever happened, I really have got no reason why I can say she did not tell me. If she did tell me, I don't recollect any of that. Yes.
So you have no recollection of the two of you having that discussion when she would have told you that?
No, not at all.
Yes.
Also, really, in Parliament, our committees and different committees, we finish very late. Take the protection of information, we'll finish round about 1 in the morning. Saturdays I'll go, I've got a constituency at Inanda, and I'll come back on Monday. There's very little time to really, for a person to be caught by a state president and come back and tell you all the details that I learned about them when I was watching the television. So I've got nothing against Miss Mentor. She's my sister, she's my comrade, she's my neighbor, she was my neighbor at that time, but I just don't recall her telling me that.
If I may then just follow up on that, let's leave the conversation of 2010 or the direct offer to her by Mr. Ajay Gupta. Have you and Mrs. Mentor ever had any discussion regarding offers of appointments as ministers by the Guptas in general, or anyone who's not the president? Have you had a conversation that would fit that bill?
Maybe it will help this commission for me to say, as much as we're all members of the African National Congress, there were those who were sitting in the NEC, National Executive Committee. I've never sat in those committees. There were issues that were discussed at that higher level. I will be in the caucus and very productive in the caucus. My hand was almost all Thursdays when the caucus sits, because I've been inside the country for the rest of my life. And I would like to see my country going right. But when it comes to issues that are discussed in NEC, at NEC meetings, people being promised this and that, as much as I'm mentally okay, high up there, but I was not at that level. I was not attending the NEC meetings. Because to be honest, I learned so very late that a Gupta, there is a surname called Gupta. I stay in Durban. There are so many Indians in Durban. I can count a list of surnames. I've never came across a surname Gupta. Coming from intelligence, I thought it was just a project. Capital letter G, capital letter U, capital letter P, capital T, capital A. And from the intelligence rules, when you are not involved in that, you are less concerned. Because before I went to Parliament, I was the instructor in NIA. So my veins and everything about me, even before we were unbent as a country, that's what I was doing the most. So I never interfere when I'm not needed. It was after so many years that, this Gupta is a surname, and I thought it was a project called Gupta. So really, when it comes to the levels, I was not in that level of knowing all those things.
But am I correct is my understanding correct that what you are saying is anything about Ms. Mento having been offered a ministerial position by the Guptas is something that, as far as you recall, you had for the first time when this commission was hearing Ms. Mento's evidence? Am I correct in understanding your evidence to be to that effect?
Yes, I think there was also a public sitting like this before this particular commission set, which was not this year, which was not last year. There was a public setup where she first got to be known by the masses of the country, pronouncing that. I got to know about it at that time.
For the first time?
For the first time.
Okay, thank you.
Chair, unless there are other questions, that is the evidence of Mrs. Mgabadeli, unless the Chair would require clarification on other issues.
No, I think that's it, because I think it's quite clear that what you are saying is whatever you had, as far as you can recall, is what you had through the public, in the public domain, not in a private discussion.
Yes,
that's as far as you remember.
Yes, Chair.
Yes. Okay, no, thank you very much.
Thank you, Chair.
Thank you for coming to share that with us. You might not maybe appreciate the importance, but it's important because it's an aspect of the terms of reference that is quite important to the Commission, whether or not certain ministerial positions were offered to certain people. Thank you very much. You are excused.
Thank you.
Thank you.
Thank you, Chair. With that, I think I'll hand over to Mr. Maleka.
Yeah, thank you.
Thank you. If you will be excused.
Mr. Maleka.
Good afternoon, Chair. The next witness is Mr. P.S. Marsden. May I ask the registrar to administer the oath?
Good morning, Mr. Maleka. I've just looked at the watch. I guess it's been a long morning. Or is your watch different?
I'm sorry, mine is ahead of yours.
Okay, the registrar can administer the oath. Mr. Maleka, before you, while the registrar is administering the oath, I would like to dispose of Mr. Van Rooyen's application for leave to cross-examine either at some stage today or tomorrow. So if, maybe we should say tomorrow. So if somebody can confirm that there's nothing outstanding, otherwise I can announce my decision tomorrow.
Yes. Chair, as far as we know, all you needed to do from all the affected parties is before you.
And Mr. Fuzile's lawyers at some stage mentioned about bringing something. They are not bringing anything.
I believe that they have, and I believe that what they have
Something to be
submitted
dealt
is
with
before you.
separately.
Is before you.
Oh, I haven't seen it. Is it an application for leave to cross-examine
Yes.
him?
Yes.
Oh, then I can deal with that
Yes.
separately.
And you know our views on this score, of course.
Well, we must just, I'm not going to deal with that one
Yes.
because I don't know if processes have been completed, whether Mr. Van Rooyen has had a chance to respond or not to that one. But I'll deal with Mr. Van Rooyen's application because from what you are telling me, it looks like all processes have been completed
Yes,
as far as
Chair.
that is concerned.
Yes,
Yeah.
yes.
So tomorrow I can then announce my decision in regard to Mr. Van Rooyen's
Yes.
application. Then I can look at the other one, and processes would need to take their course.
Yes.
And at the right stage, I can make it.
We'll be grateful because you know that we are eager to complete the evidence of Mr. Fuzile.
Yes. I haven't seen that application, so somebody must just make sure that I am in possession of it.
We will liaise with your registrar during the lunch adjournment to make
Yeah.
sure that she
Yes.
reminds you when
Yeah.
it was submitted to you.
Yeah. Well, I've got the Van Rooyen one. It's the new one that I don't have.
Yes.
Yeah. But
Or we'll make an extra copy for you.
yeah, that's fine. Yeah. Okay. Thank you. You can go ahead.
Tandy.
Please state your full names for the record.
Piers
Did you
Michael
give-
Marsden.
Do you have any objections to taking the prescribed oath?
No.
Do you consider the oath to be binding on
to
your
the
conscience?
Yes.
Do you swear that the evidence you give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you.
Chair, before Mr. Marsden starts, may I record that he was one of those persons who assisted the public protector to investigate matters relating to the Business Rescue Administration of Optimum Coal Holdings and Optimum Coal Mine.
Yes.
He is also one of the persons who orally testified before the Portfolio Committee on State-Owned Enterprises.
Yes.
We have submitted the transcript of his version together with the bundle of the transcript that Ms. Norman took you through
Yes.
on the, I think, 18th, if I'm not mistaken. But we have also prepared a separate transcript for you of his testimony before the Portfolio Committee.
Okay.
I'm not too sure whether it was given to you in a small blue file.
Well, it certainly wasn't drawn to my attention. Sometimes people think they've given me things when they've just put them where I'm supposed to see them. I see a certain file here. I don't know about
No,
it,
that's
but
not the
maybe
one.
it's not the one.
No, that is the copy of the legislation we dealt with yesterday.
Yesterday.
But we will get to it after
Yeah, in due course.
lunchtime.
Okay. There, but let me check whether I've got what you have got in front of you. What exhibit is the one, is that one that you have got?
The file of Mr. Marsden, I believe it's U10. U11.
I do not have any file marked exhibit U11 or U11. I've got one marked exhibit U10 or volume 10.
If you look at the
There
spine,
is one. Okay. Okay. I think it's because it wasn't drawn to my attention, and I think I'm hearing about U11 for the first time. So it's we should mark it exhibit U11.
it is marked at the back.
Yeah.
And you'd remember you requested that there should be.
Yes. I'm happy to see it's beginning to happen.
Yes, yes.
If all of them, including those that are at
Yes.
home, can be marked like that, that would be grateful.
And together with that file, you'll see a ring-bound bundle.
Yes.
Oh, that one that you're having.
Yes.
That's a transcript of Mr. Marsden's evidence before the portfolio committee.
Yes.
We would like you to have it at hand.
Yes.
Because at some point, depending on his answers, we may have to remind him about what he said to the portfolio committee.
Okay.
Mr. Marsden, I can fairly and comfortably welcome you by saying good afternoon.
Good afternoon.
Can I make sure?
He might have to look at his watch too. Yes, you may proceed.
Thank you, Chair. Mr. Marsden, the investigators of this commission asked you to prepare a statement for the purposes of your oral testimony to this commission, correct?
Yes.
And you've had some discussions which ultimately led to a statement that you prepared and signed on Monday, this past Monday.
I think it was Tuesday, but yes.
Tuesday.
It was yesterday.
Yes. Accompanying your statement that you signed on Tuesday was a set of annexures, correct?
That's correct.
And they too were put together in a bundle by attorneys representing you. That's Worksman's attorneys.
That's correct.
Yeah. All of those documents are now before you, and they have been placed before the chairperson as exhibits U11. You have had an occasion to look and re-look and re-read the statement, correct?
That is correct.
And do you confirm that that statement correctly reflects your recollection of the events relating to your functions and duties as a business rescue practitioner for Optimum Coal Holdings and Optimum Coal Mine, Pty Limited?
I do, yes.
Yes. Is there anything that you'd like to reflect on the contents of the statements before we start with your evidence? Or you're fairly comfortable that it represents the truth to the best of your recollection?
I'm fairly comfortable, yes.
Right. I would then ask you to go to page 1 and ask you something about your background which is not there. You record in paragraph 1 that you are a chartered accountant, correct?
That is correct.
When did you qualify?
I qualified in 1998, and then I did my articles, so it would be in 2001, 2002, around there.
And when did you complete your articles?
In 2001.
And thereafter?
Thereafter, I did a brief stint with Deloitte in the US, and then I came back and effectively worked for a number of different organizations, principally in the distressed business environment, prior to and subsequent to the promulgation of the new Companies Act, which obviously then included the business rescue as a further tool for assisting distressed companies.
Yes. It's a new chapter in the Companies Act.
Yes.
When did you yourself become listed or registered with CIPIC as a business rescue practitioner?
Pretty soon after the promulgation, so I think it was effective in 2011, so in probably the 5 or 6 months after the act became effective.
You know Mr. Peter van den Steen?
I do, yes.
In what capacity?
He is a fellow and co-practitioner, and he was a co-practitioner on both OCH as well as OCM.
Yes. So you jointly work together in trying to rescue both those companies.
That's correct, yes.
When did you start with your functions and duties as the BRP for these two entities? Talk about it in time.
So our effective appointment date is detailed in the file. According to my recollection, I think it was early in August of 2015. And effective from the registering of those particular documents at the CIPC, our appointment as business rescue practitioners is effective immediately thereafter.
You can go to page 2 of your statement and look at paragraph 5.
Yeah, so the 4th of August.
The 4th of August.
That's correct, yeah.
Right. At that point in time, there had been some developments between Optimum Coal Holdings and Optimum Coal Mine on the one hand, and Eskom on the other, which led to the decision of those two entities to initiate the business rescue proceedings. I take it that you're aware of those developments.
Yes.
Part and parcel of them involved the decision by Eskom's then acting group chief executive officer to impose and require penalties in the order of 2.1 billion rand to be paid by Optimum Coal Mine to Eskom.
Yes.
Yes. And once you took over as a business rescue practitioner, you had a fair sense of what the financial condition, including the asset and liabilities of Optimum Coal Mine were, correct?
Yes, correct, yes.
Give us a sense of what you discovered immediately after you and Mr. van den Steen took over.
I think what was apparent, and maybe if we could just deal this in two parts. First of all, at OCM, and then secondly at OCH, given they are different legal entities with different perspectives. At OCM, we found, as you've alluded to, that there was a contract with Eskom at the point in time. It was, to all intents and purposes, the sole customer of the Optimum Coal Mine. There was a long-term agreement in place, and the company was experiencing significant cash losses on a monthly basis. Essentially, it was selling coal to the tune of about approximately 150 Rand per ton delivered, and its production costs, its cost of production, were about 430 to 450 Rand per ton. So rather substantial losses. It had exhausted all of its internal resources, and it therefore relied extensively on its shareholder in order to continue to survive and continue to meet its obligations. Its immediate shareholder was Optimum Coal Holdings, so perhaps if I can address that next. This, as the name suggests, was a holding company. It had no operations, no employees, no creditors other than a banking facility. And so Optimum Coal Holdings existed as the holding company for several entities, of which Optimum Coal Mine was one. And in addition to the bank debt that sat at Optimum Coal Holdings, it had signed a guarantee for the obligations of OCM to Eskom.
But so it too, at that point in time, was in business rescue.
As a result, as a direct result of the guarantee.
And therefore, a company in business rescue cannot look into another in business rescue to assist it, financially at least.
Well, I think not only would it be difficult for a company to justify supporting a company that's clearly financially distressed, the guarantee essentially made it as a co-principal debtor on the hook for the obligations of OCM. And as a result, the 2.1 billion fine that you alluded to, from a legal point of view, could then be applied either to OCM or alternatively to OCA.
I'd like to fast-track that part of your evidence because it is really common cause.
Yes.
Where I wanted to get to was to try and understand whether or not you had an appreciation of the extent of the loss by OCM, that is the mining entity at that point in time. We had evidence from, amongst others, Mr. Clinton Efron. I take it you know him.
Yes, I do.
That the extent of the loss was in the order of 150 million rand.
It would certainly be in that amount, absolutely.
Yes. So The 20 penalty that were imposed had a significant impact on the financial condition of Optimum Coal Mine in two respects, correct?
Absolutely.
Can you identify those respects for us?
So I think the most obvious one is a demand for 2.1 billion, i.e. it would have had to find the means to settle that initial fine. And the second and perhaps more significant issue is that following through on the application of that fine, so the fine was retrospectively looking, historic deliveries of product that had already happened and where the coal had been consumed by Eskom. But applying that methodology in terms of the contract going forward would have meant that the coal that was previously supplied at 150 would effectively have had to be supplied at 1 rand per ton, thereby greatly increasing the already quite substantial losses on a monthly basis.
Can I ask you to pause there and just clarify a few things? So as you come in around August 2015, there is at least an accounting liability of 2.1 billion rand arising from the penalties, correct?
I mean, I think it would be a contingent liability because there were certainly grounds on which the claim could have been opposed.
Oh, yes.
So, I mean, whether one would accrue it as a full liability, probably unlikely, but most definitely, given that papers had been prepared, I would certainly suggest a contingent liability.
Of course, but in an accounting terms, you have to account for it as a contingent liability. You can't ignore it.
You certainly can't ignore it.
Yes. And then from that point on, August 2015, going forward, there was also another contingent liability that you had to account for. That is the effect of the penalties on the stockpile of coal Optimum was required to supply to Eskom on a month-to-month basis, correct?
Absolutely. To the extent that Eskom wished to pursue that interpretation of the contract, you're absolutely correct. There would have been an obligation to supply at 1 rand per ton for the remainder of the contract, or until such time as it was outside of the sort of claim of the penalty.
Yes.
But you're correct in terms of the forward-looking loss would have been a liability that anybody looking to acquire that or looking to fund that business would have had to understand quite intimately.
Yes. And as you have indicated, Eskom was the primary, if not the sole, client of Optimum Coal Mine in the country.
That's correct, yes.
So it means that the condition you found the mine at that point in time is that it would not have earned any significant income from the supply of coal to Eskom. Instead, it will continue to suffer a loss.
That's and an ever increasing loss given the application of the 150 to 1.
Yes. I don't know whether you'll be able to do the mathematics for us, but on your approach, the CSA required Optimum Coal Mine to supply at a price of 150 rand per ton. On your calculation, it would be required to supply that stockpile of coal for 1 rand per ton. So the losses would be around 149 rand per ton for each stockpile.
Well, the losses would be a lot more than that because the costs of production were 440.
Yes.
So the additional losses would have been the 150 to the 1. So if one were to calculate the total losses, it would have been the obligation to supply, once again, I hope my maths is reasonable, approximately 5.5 million tons per annum to Hendrina in terms of the contract, at the cost of production, given that your revenue would be 1 rand. So that would be in the region of 450 rand per ton, multiplied by 5 million tons.
So it's about 449 rand per ton.
Correct. So, I mean, a number of billion, I think, in my rough calculation, probably in the region of 2 billion rand.
All right, we'll work with that number. What did you do when you realized that that was the scope and scale of the financial condition of Optimum Mine when you took over?
So I think there were a number of things. One of the requirements from a practitioner is to investigate the affairs that involved trying to get an understanding of some of the history of that contract, some of the aspects that occurred prior to business rescue. But certainly what became very apparent is that any solution and any tools that a practitioner would have in order to try and advance the business rescue would require the cooperation, assistance of Eskom as well. So one of the first things that we did was attempt to engage with Eskom around a number of items. Number one, some form of an interim supply in which we could continue to meet those obligations through an interim period. And then second of all, to try and find a long-term solution which would have resulted in a more sustainable business for the mine.
Yes. You indicate that Eskom was critical to any prospects of rehabilitating the financial ill health of Optimum Coal Mine. And you do, of course, know that the connection between Optimum Coal Mine and Eskom at that point in time was the agreement to supply coal called the CSA, the long-term supply agreement.
Yes.
It's common ground, and I'm sure you know that all things being equal, that agreement would have come to an end around 31st of December 2018.
That's correct.
So by the time you came in, it had a lifespan remaining of 3 years, correct?
That's correct, yeah.
Did you have occasion to look at how that agreement in its terms up to the second or third addendum at that point in time impacted on the ability of Optimum Coal Mine to financially rehabilitate itself?
Absolutely, and I think some of this ground has been traversed by other witnesses, but certainly there were a number of aspects of that contract. The first was that there was always the intention that there would have been some element of cross-subsidization. It was a big mine. It was able to generate more production than simply the obligation to supply Eskom, so there was certainly an ability to cross-subsidize the same coal by exporting that, and then obviously using the profitable portion of the mine to subsidize the non-profitable portion of the mine. Unfortunately, when we arrived there, the coal price was at an extremely depressed state and there was no export coal being produced. The second aspect is that that contract escalated at a particular rate, and in reality, the escalations of the cost of production had for some time exceeded the anticipated escalation in terms of the contract. So there was effectively a point at which those costs had simply escalated beyond what the increase was determined to be in the contract as well.
Chair, Mr. Marsden deals with that issue of the impact of the CSA on page 4, paragraph 13 of your statement.
Yes.
Having gained a picture of what animal you were dealing with, you began to take processes to try and see whether there would be some hope to save it by beginning with engagements with Eskom, correct?
That's correct, yes.
You detail those engagements from page 5, paragraph 15.
Yes, so we attempted on numerous occasions to meet at the appropriate levels within Eskom, and we were able to do that after some time. As we've mentioned, we were appointed on the 4th, and almost immediately afterwards we would have attempted to make contact with them. We were finally able to get an engagement with Eskom on the 17th, as detailed on page 5, and it really was an open invitation to Eskom that we were independent parties. We were here to attempt to find a solution to a challenge that was both a concern, I would have thought, for Eskom as well as for shareholders and creditors of OCM.
Who initiated the meeting of 17 August 2015?
We would have initiated it.
And who from the side of Eskom attended that meeting?
As far as I can recall, it was attended by Ayanda and Teta, by Machela Koko, by myself, by my fellow practitioner via teleconference, and I think that Jabu may have been there as well.
Who was Jabu?
He was, I think, at the time the acting head of primary energy.
All right. I'm sure there were discussions that were held at that meeting.
I'm sorry, what was Jabu's surname?
It's just not coming to me right now, but I'm sure I can get you the details of it.
Yeah, well, I hope we'll remember so that we can refer to him properly,
Yes,
not just as Jabu.
I don't know, but you're right, we will.
This is not right.
Yes.
Yes, sir.
What was the upshot of that meeting?
So I think the purpose of that meeting was to discuss the business rescue, what the potential impacts of what the process was like, as well as to attempt to open discussions with Eskom around a possible renegotiation of the coal supply agreement in order to avoid a liquidation, which is really the alternative if there is not a solution to finding a business rescue solution.
Yes. But what happened? I mean, did you meet each other, or was there no positive outcome?
There was no positive outcome. The sense that we got from the meeting was that Eskom and OCM and OCH had a very strained relationship, and certainly we found Eskom to be relatively cold to our advances in terms of attempting to find a solution.
In paragraph 16, you say that Eskom was unwilling to commence negotiations with OCM.
That's correct, yes.
What led you to believe that Eskom was not willing to engage with OCM?
I mean, we had made numerous attempts to meet with them. We had finally got to the point where we did have a meeting. And as you pointed out, there were really no clear points of going forward points determined at that meeting. We certainly didn't get the view that the urgency that is placed on us as practitioners was necessarily reciprocated by Eskom, and we were not able to get to the point of a forum in which we could commence the negotiations.
Yes.
Maybe Mr. Maleka, let's revisit Mr. Marsden. When I said that it's not right to just refer to him as Jabu, whoever the person is, I didn't mean that you intended anything negative. It's just that because these are formal proceedings, it's better to refer to people as Mr. So-and-so, Miss So-and-so, Dr. So-and-so, Professor, whatever. And in the past, there have been witnesses who, because of their relationship with the person, sometimes just call the name, but I think certainly from the evidence leader's side and from my side, we have tried to use their surnames because it's the right way for this kind of forum.
No,
I just want you to know that I'm not necessarily saying you used Jabu because you intended anything negative.
And I must apologize to the Commission equally.
Okay,
Yes.
no, that's fine.
Chair, the mistake is us. We did not forewarn Mr. Marsden
Yes, okay.
about
Okay.
the customary formalities of these
Yes.
proceedings.
Okay, no,
But
that's fine.
let me take the apology
No, that's fine.
for him. Let me make the apology for him. Mr. Marsden, I mean, once you realized that there was no productive engagement with Eskom, you did something.
Yes.
As the managers for the time being of Optimum Coal Mine.
Absolutely. One of the key features of business rescue is the ability to suspend obligations of a contract. So certainly that is one of the most powerful tools in the business rescue practitioner's toolkit. It's not something that one does lightly. It's not something that one does in haste. However, we elected to use that mechanism on Eskom, and we effectively terminated or suspended the coal supply agreement, which obliged us to supply coal at that rate to Eskom.
Yes. And you relied on the provisions of Section 136, subsection 2A of the Companies Act.
That's correct. So that sits within the Business Rescue Chapter 6 legislation and is available only to business rescue practitioners.
Yes. Yes. What did you hope to achieve by suspending the supply of coal to Eskom?
I think a number of things. I mentioned the word urgency, and we touched on it in our papers, and we haven't discussed it necessarily here today, but the time constraints placed on us as practitioners in terms of the Act are pretty clear, where a plan has to be published within 5 weeks. But more importantly, given the losses that were being made, we didn't have the luxury of time. So certainly, in order to create some urgency and get the attention of Eskom, certainly that was an attention. And I think it also sought to perhaps illustrate that we did not have an open checkbook in terms of which we as practitioners could continue to incur losses. That's not our mandate. Our mandate is to restructure and to resuscitate a business, and we certainly could not sustain that for any period of time.
Yes. As I recall, in terms of the New Companies Act, you had a period of 3 months to formulate a business rescue plan, correct?
It's actually shorter than that. It's a period of 25 days in which you have to publish a plan for consideration for creditors. The 3 months is if it's not been concluded, i.e. the plan presented, adopted, and implemented within 3 months, there's a whole bunch of regulatory items. So the timeline is even more compressed than the 3 months.
Yes. So you still had time by the time you suspended coal supply to formulate a plan.
Absolutely, but very little.
Little. And you say that you informed Eskom about the suspension of coal supply to it. And Chair, you'll find a reference to the letter from the Joint Business Practitioners to Eskom, referred to in paragraph 16 on page 5.
Yes.
It is PMM7, and you'll find it at page 64.
Yes, thank you.
You are aware of it, Mr. Mazen, but can I just highlight some few aspects of this letter? Are you at page 64?
I am indeed.
Who is it addressed to?
So it is addressed to Mr. Koko and to Mr. Mboweni. And I must now extend my apologies further to the Commission. That is the gentleman to whom I referred to earlier. Mr. Vusi Mboweni was at that prior meeting, so my apologies.
All right.
Is that the one in respect of whom you used the name Jabu?
That is correct. My apologies. But yes,
so
I see
the
the name
was
is,
the mistake.
it was a complete mistake.
Yes.
On my part.
Yeah, okay, thank you.
Chair, I did not know someone Jabu, so at least the confusion is cleared now. But it is also copied to someone else. Who is it?
So it is copied in CC to Ayanda Nteta, who was also present at that previous meeting, as well as to their legal advisors, Cliff Decker Hofmeyer, for the attention of Rishabhan Mudli.
Yes. All of these addressees were not new to you. You had met them at the meeting of the 17th of August.
That's correct.
You say something in paragraph 4 which is quite interesting. You refer to the cooperation agreement which was previously concluded between the parties on the 23rd of May 2014. Do you see that?
Yes, indeed.
Did you have occasion to look at the terms of that cooperation agreement?
Yes.
And you know the background to it?
I do.
It related to the suspension of an arbitration between the OCM entities and Eskom relating to what was declared as a hardship
That's correct.
by OCM.
Yes.
Arising from difficulties relating to the costs of operating that mine. Correct?
That's correct, yes.
So that agreement was raising something that you two had concern about relating to the CSA and its impact on the ability of the mine to run profitably.
Absolutely, and certainly that informed a lot of our decision-making going forward, in that there was, and had been prior to business rescue, an attempt to resolve this. And I think a lot of good work and a lot of good time had been expended by both OCM not in business rescue, as well as Eskom in terms of trying to determine a solution. So certainly a reliance to a certain degree on that was something that we placed in terms of the fact that both parties had attempted, unfortunately not succeeded, but attempted to restructure the agreement, and there was certainly a history between the parties in that context.
The impression I gain from your evidence is that it must have been clear to both parties to the contract what the drastic impact of the CSA was on the ability of OCM to supply coal to Eskom.
It was apparent, and I think even more so in the context of business rescue. I can't imagine a multinational like Glencore would take a decision lightly to put one of its subsidiaries in the hands of an independent party in the context of insolvency as well. So not only were the numbers apparent, but I think the context of actually putting the company in business rescue just really illustrates the point even more clearly.
I also gained the impression that it must have been clear to you as the manager for the time being, and also Eskom as the client of the entity you were managing, that there was a risk of not procuring a security of supply of the coal to Eskom because of those difficulties you've explained.
Absolutely, and I think business rescue is in some terminology a purgatory, right, where you're in the last chance saloon. And to the event, in the event that we were unable to procure funding to continue the business rescue or we failed to find a solution to the business rescue, there's a positive obligation in the business rescue section of the Companies Act that requires a practitioner, in the event that he believes that there is no longer a viable option to rescue the company, to place it into business rescue. So it's kind of an iterative test that one goes throughout a business rescue process. To the extent that you ever reach the conclusion that there's no longer a reasonable prospect of rescuing that business, a practitioner is obliged to place a company into liquidation, the consequence of course of that being that there would no longer be supply to Eskom.
Even before the prospect of litigation became real or likely, it seems to me that at that point in time, the parties must have appreciated the risk to one another relating to the difficulties posed by the CSA.
Yes.
I pose these questions to you now because later on we will converse correspondence emanating from Eskom showing that they appreciated the strategic importance of Optimum Coal Mine as a useful asset to supply coal and secure security of supply to Hendrina.
Absolutely.
Are you aware of that?
Absolutely.
Also for the supply of coal and to secure security of supply to Arnold Power Station.
At this stage in the business rescue, there was no supply going to Arnott from this power station. So certainly its proximity to the Arnott power station, the mine's proximity to the Arnott station would have made it potentially compatible. But at this point in time, it was supplying solely to the Hendrina power.
You can accept, and the chairperson has said evidence, that from around December 2015, January 2016, coal from Optimum Coal was bought and traded to Eskom for the supply of Arnold Power Station.
I'm aware of that.
We are aware of those things.
Absolutely.
And there were representations made by executives of Eskom about the strategic importance of Optimum Coal's coal from Optimum Mine to Arnott. Are you aware of those representations?
I'm not aware of internal.
Well, I'll take you through them. Yes. But what I find surprising is this: with those risks appreciated by the parties, you could not find one another.
We could not.
From your perspective, why was it so difficult to find one another? because this seems to be something which the parties had to work jointly with a view to find a compromise position.
I think that we attempted, and it's certainly in the documents, to provide a number of different solutions. Certainly, my experience has been previously, even if a solution is unacceptable to another party, there's some level of back and fro, some level of counter-proposal. Eskom's position was steadfast and unmoving with regards to the fact that they had a contract until the end of 2018 and that they expected that contract word and verse to be delivered on throughout the time from 2015 all the way until the end of 2018. And throughout the process, that was their red line. There was no movement on that particular issue.
Yes. One of the issues you proposed to Eskom is the prospects of an interim agreement to supply.
Yes.
And you propose that option in paragraph 7 on page 65 of the letter we're looking at. Are you there?
Yes, I am.
Can you just indicate to us what led you to make this proposal?
Historically, the mine had been funded by its shareholder. Within business rescue, that option is not necessarily guaranteed, and one is required to fund those losses by means of post-commencement finance. And in the absence of that, whether I wanted to or not, I simply could not continue to incur those losses. I would have run out of cash. So we had put together a proposal whereby effectively, for an interim period, whilst we were attempting to find a solution, there would be an interim arrangement which would see that security of supply guaranteed whilst negotiations continued.
And you, in that letter, annex a copy of the proposed interim agreement, correct?
That's correct, yes.
Chair, we have looked at this at some point, but look, the terms of the interim agreement mirror aspects of the fourth addendum.
That's correct, yes.
That was in a draft form but rejected by Eskom.
Yes, that's right.
Yes. And in paragraph 8 of your letter, again at page 65, you say that Eskom was not moved to consider that interim proposal, correct?
That's correct, yes.
I'd like you to reflect on this. I mean, Eskom is now facing a clear decision by you that you're not going to supply coal, correct?
I think more than that, the decision's been made and the conveyor belts at this point had actually stopped delivering coal.
So there was no supply of coal at all to...
We suspended the obligations and switched off the conveyor belts.
And that's the operation of the law. And
Correct.
yet they insist that you should comply with the CSA, which on practical terms has been suspended.
That's correct.
How can you comply with something that by law has been suspended?
I think their intention was that to the extent that the resupply commenced, any solution to the business rescue would have required the CSA to remain intact.
No, but you have already suspended
Correct.
the agreement, and you're entitled to do so by law.
Correct.
How can they insist then that you should supply when by law the agreement has been suspended?
They couldn't insist. What happened subsequent to that was a meeting was called by Eskom, and I think you certainly covered it with Mr.
Well,
Efron,
we can
because
go
I was merely sitting outside, but and I'm not sure what clause it is, but the intention of the suspension certainly worked in that we then were able to get an engagement with Eskom at the highest level.
As a matter of sequence,
Yes.
let me take you back to your statement on page 5. Remember, you suspended, and on your approach, the conveyor belts were shut around the 20th of August 2015. And you say as a result of that suspension, there was a meeting convened by ESCOM, and you refer to that meeting in paragraph 17 of your statement.
That's correct.
So there must have been a period of about 13 days during which there was no supply of coal to ESCOM.
I can't remember the exact days, but absolutely there was a period, and that appears to be the
Yes.
correct period.
Do you know where Hendrina would have obtained its coal during that period?
They would have had a modest amount of coal available on stockpiles already delivered to themselves, and they would have then been able to truck in from third-party suppliers as well, which they certainly did.
We have evidence to show that third-party suppliers were at rates higher than those that Optimum Coal supplied to Hendrina.
That would not surprise me.
Okay. Chair, you'd recall that Mr. Opperman referred to a short-term agreement, and the rates that we explored with him were fairly higher. Yes. But you are not aware of them, but you wouldn't be surprised.
Not in the slightest.
All right. What happened at that meeting of 3 September?
I'm loath to call myself a participant in the meeting.
Well, just take us through
But,
what happened. We know that the meeting was called by ESCOM. Who attended?
So a meeting was called. I received the phone call from the chief executive, Mr. Molefe, for a meeting at Megawatt Park. I was invited, as was Mr. Van den Steen, my co-practitioner, and I was requested to ensure that Mr. Efron was invited as well. So we were invited up to the executive section of ESCOM, at which point...
the third floor of Megawatt Park?
Indeed, yes. And we were enjoying some good coffee outside there when Mr. Efron was called to a meeting, and myself and Mr. Van den Steen were left drinking coffee outside.
You were invited to a meeting and you don't attend the meeting?
That is correct.
Why not?
We weren't sure if the meeting that was happening in our absence was perhaps a pre-meeting, or that we would be invited at some point in time. That didn't happen, and so it was most unusual.
And what happened after the meeting between the executives of ESCOM, Mr. Molefe and Mr. Efron took place?
Mr. Efron came out and told us that the meeting was finished. We then left the building, and either on the way out or immediately afterwards outside, Mr. Efron recorded to us what had happened at the meeting, and essentially he would need to get consent from his stakeholders, but essentially if Glencore were prepared to fund the losses on an interim basis, would we as practitioners agree to recommence the supply on an interim basis with a couple of key factors. Number one, the price would not be at the stated R1, but more like the 150 that it was originally. ESCOM had defaulted on 2 months' worth of previous payments. There was a condition that they needed to pay that amount, and then the payment terms were changed from, I think, 30-day statement to effectively every 7 days.
You were not at that meeting.
Yes.
Mr. Efron tells you what was agreed at that meeting.
Yes.
And after you gained a sense of what happened, you put in writing your understanding of what was agreed and sent your letter to ESCOM.
That's correct.
And Chair, that is all dealt with at page 6, paragraph 19, and the letter of Mr. Marsden and his colleague is at page 74 and 75.
Thank you.
You have had a chance to look at this letter, correct?
That's correct, yes.
And it sets out what was supposed to be an agreement at the meeting between Mr. Molefe and Mr. Efron. Was there any comeback from ESCOM to say what you had put in writing was not a correct reflection of what was agreed at that meeting?
Not as far as I can recall.
Not as far as you're aware. So on that premise, that those would be the terms of the interim agreement, what happened thereafter?
So the interim agreement had a very important condition, or several important conditions. One was the resupply. So just from an operational perspective, we again began to supply the Hendrina power station. The most important aspect from our perspective was that the parties would give one another 60 days to commence and hopefully conclude good faith negotiations on a longer term solution, i.e. beyond the interim 60-day agreement.
Yes. So you supplied and were you paid?
That's correct.
Yes. And you say in paragraph 20 of your statement that ESCOM began to engage earnestly with the difficulties of Optimum Coal Mine by calling for information relating to its financial condition.
I'm not sure if I said they engaged earnestly, but certainly they began to engage.
Well,
principally at the start with the request for financial information pertaining to the costs of the operation.
But did you doubt their good faith when they began to call for information from Optimum Coal Mine?
I think we had the seeds of doubt, given that this information had been extensively audited by ESCOM themselves prior to business rescue. I think we heard testimony yesterday, happened to be in the room, from Mr. Opperman, who conceded that both Nedbank and another sort of consulting company had been provided and gone through this information. So we thought that whilst it was positive to now have some engagement, we certainly had a concern that there was a lot of redundancy in terms of information that had already been provided, but regardless, we provided it.
Yes. But you're not suggesting that ESCOM was playing marbles when it called for this information?
Let's give them the benefit of the doubt.
Yes. I'm sure you provided that information.
We did.
What was the next phase of the development relating to the negotiations?
So in parallel to the negotiations, we had received an unsolicited bid for the business, and we received several of these throughout the process. So we were not certainly running a formal process to solicit bids, but we received on the 10th of September, just going chronologically in terms of the statement, a unsolicited, non-binding offer from Oak Bay Investments.
Yes. Chair, that was what was referred to as the first offer, the first Tegeta offer. Yes. We have looked at it. I don't think that we should waste time and burden the record by considering it.
It's not necessary.
Yes. We have had evidence on it. What did you do once you received that offer?
Yeah, as I said, it was really in parallel with our engagements with ESCOM, so we're not really considering the sale of OCM at that point in time. We were focused on the engagement with ESCOM. And you know, we kind of not treated it with it glibly, but we didn't consider it in too much detail. Our focus was very much on the ESCOM renegotiation.
Yes. One thing that is interesting from your perspective of what that offer said is the statement you make in paragraph 22 of your affidavit, the last statement, where you say that the offeror at the time indicated, amongst others, that it was confident it would be able to secure ESCOM's consent to the transaction, correct?
Yes, that's right.
You know that under the original CSA as amended by the first to the third addenda,
yes,
ESCOM was entitled to consent or refuse consent for the cession of that contract.
Yeah, I believe they had change of control provisions as well. So they were certainly, as I mentioned right at the start, an absolutely fundamental player in any business rescue context.
What I find interesting with this offer is that it indicates to you upfront that the potential buyer would be able to secure the consent of ESCOM. How did you consider that expression of confidence from the buyer? And I'll tell you why I'm asking this question.
Yes.
You know that another bidder also sought to establish whether ESCOM would consent, and ESCOM indicated that it would not.
Yeah, we saw this as really a response to one of our conditions in terms of any transaction that we believed would require consent. So certainly we stated that one of the objectives to any offer would be that they would need to get ESCOM's consent. So I think this was a reply to the terms and conditions that we had done. They were, at the time, a supplier of ESCOM's through the Brakfontein operation. So we certainly knew that they had a relationship with ESCOM, and as a result, to the extent that ESCOM was going to consent, perhaps, they were already a known quantity.
Can I follow up if you don't mind?
Of course.
Pembani was one of the entities that was interested in making an offer to buy this mine, correct?
That is correct.
And Pembani was no stranger because it was...
Absolutely not.
Pembani was part and parcel of Optimum Coal Mine, correct?
That is correct. They were minority shareholders.
It too was supplying to ESCOM.
That's right.
So there can be a point of distinction in that regard as between Pembani and Tegeta, correct?
I think there's a slight nuance here in that Tegeta were confident that they would get ESCOM's consent. I think at the point that we initially engaged with Pembani, they too were confident that they would get ESCOM's consent. I think whether they did or didn't is ultimately where the test lies.
Well, that's important because Tegeta was quite confident well before the consent provisions were triggered. And ultimately it got consent. Pembani was frustrated by lack of consent.
Sure.
Are you able to explain the precipitous expression of confidence and the ultimate procurement of that confidence?
I'm not able to explain it now.
Well, I suggest to you that is because Tegeta was given favorable treatment from beginning to the end.
I would agree with that.
Yes. Can I take you then to paragraph 23 of your statement?
Yes.
Where you deal with the terms of the letter dated 17 September 2015. Chair, you'll find that letter as PMM 14. It is at page 101.
Thank you.
That letter is written by CDH. Do you see that?
Sorry,
Page 101.
Yeah, our offer is 13. Their response is 14. You're right. Yes.
And that's a letter from CDH, correct?
That's correct. Yes.
Just explain to us why did CDH write that letter to you and your colleague?
So if I take you back to the minutes, they were recorded as acting for ESCOM. They received that pack of information that ESCOM had requested. So we were kind of engaging either lawyers or practitioners directly to them. We had provided that information in earlier on in the month, and then after an appropriate amount of time, we had proposed a solution. And this letter is in response to that proposed solution.
Yes. And it is quite clear from the legal representatives of ESCOM that they rejected your proposal.
Absolutely, and I think what's important is there's no counter-proposal or any stipulation on the way forward.
Yes. You record in paragraph 24, at page 6, page 8, I'm sorry.
Yes.
Paragraph 24, that the negotiations came to an end around 5th February 2015.
October.
5th October 2015. Do you see that?
Yes, indeed.
What did you do after Eskom made it clear that it was not going to pursue further negotiations in terms of your proposal?
So I think what we had come to the conclusion of, and going back to what the objectives of a business rescue are, the objectives of a business rescue are to restructure a company, its affairs, etc., and that's envisaged to be a restructure of the legal entity and its contract and affairs. What became apparent to us throughout this period was that there was clearly a history between the parties, and to the context that Glencore was a shareholder, we were unlikely to make any further headway with renegotiating the CSA. There was simply too much water under the bridge. So going back to our business rescue, we then proceeded to say, well, what is the next alternative to restructuring it? And there is one more step prior to no alternatives being left, which would have been a liquidation, which is an outright sale of the asset, and that achieves the second category of business rescue, which is a result better than a liquidation in business rescue. So at that point in time, we really went back to the drawing board, put a line through our attempts to renegotiate the CSA in the context of Glencore as a shareholder, in context of the entities as they were, and changed tack to a certain degree.
Yes. But that too failed, and the options were becoming narrower and narrower.
That's correct.
And in paragraph 25, you say that one of the options that you considered in the narrow scope was a sale of the asset.
That's correct, yes.
And what happened to that option? I mean, did you trigger it, or?
So I think we advised Eskom that we had a number of options. The first was the sale of OCM to a third party.
Yes.
The second was the sale of OCM to Eskom themselves.
Yes.
And the third was the sale of OCM to a third party, but via a competitive process. The distinction being the first and the third being one was a kind of a bilateral discussion, whereas the third we would have effectively solicited bids on an open basis, as a distinction between options 1 and 3 there.
Yes.
We indicated that we had received an expression of interest and from a party which would have fitted into that first category, a bilateral discussion.
Yes.
And that was, once again, as mentioned, the Oak Bay offer.
And those options were communicated to...
I think it's time.
My apologies.
Yeah, you didn't.
Was
keep an eye
disorientated by the fact that we started late when I thought we started early.
Yeah. We are going to take the lunch adjournment and resume at 2. We adjourn.
Thank you, Chair.